Good evening. Welcome to the Costa Mesa Planning Commission meeting for Monday, February 11th, 2019. I call the meeting to order and am pleased to ask our newest Planning Commissioner, Kadarius Colbert, to lead the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Kadarius, very much. Okay, so this brings us to the point of our agenda where I will turn this over to our City Clerk, Brenda Green, to swear in our newly appointed planning commissioners.
Thank you. And so would the three new members join me down here, please? We'll do the oath. Watch the cool. Just right there where Julie can get some good photos right there. Okay. Please raise your right hand. Do you, Carla Navarro Woods, do you, Kadarius Colbert, and do you, Jonathan Zick, Planning Commissioners of the City of Costa Mesa, solemnly affirm that you will support and defend the Constitution of the United States and the Constitution of the State of California against all enemies, foreign and domestic, that you will bear true faith and allegiance to the Constitution of the United States and the Constitution of the State of California, that you all take this obligation freely without any mental reservation or purpose of evasion, and that you will well and faithfully discharge the duties upon which you're about to enter. Okay, congratulations.
Thank you, Brenda. And newly sworn in commissioners, congratulations. I'll reserve some comments for in a minute, but congratulations all three of you for your reappointment. And Kadarius, welcome to the panel. This brings us to roll call. Julie, please.
Vice Chair Jericho.
Here.
Commissioner Harlan.
Here.
Commissioner Navarro Woods. Here. Commissioner Zick.
Here. Commissioner
Colbert.
Here.
Okay, election of officers, Mr. Curtis.
Yes, thank you, Mr. Vice Chairman. I'd like to declare the position of chairperson of the Planning Commission open. Are there any nominations?
I'd like to nominate the guy in the middle, Commissioner Byron DeErickle, as chair of the Planning Commission.
Second. Are there any other nominations? Close it and please vote.
That motion carried 5-0.
Great, and thank you very much, commissioners. That's a big honor for me, and I appreciate your confidence, and I look forward to working with all of you over the next 2 years. And now, so I will ask for nominations for vice chairperson of the Planning Commission. Commissioner Woods.
Mr. Chair, I'd like to nominate Commissioner Harlan for vice chair.
I will second that nomination. Any other nominations? Seeing none, call for the question.
That motion carried 5-0.
And congratulations, Vice Chair Harlan. Okay, commissioners, just as a point of housekeeping, we have a new business item on the agenda, which is recognition of outgoing Planning Commission Chair Stefan Andranian, who has joined us this evening, and also our former legal counsel, Yolanda Summerhill, who is now with the City of Newport Beach. I would ask that we bring that new business item up to just after announcements and presentations, if that's okay with you.
Absolutely.
Okay. Great. And from what my understanding is, actually, Ms. Summerhill is not able to make it this evening for a family issue, so we will defer that particular presentation of resolution to our February 25th meeting. Announcements and presentations? You have none?
No.
Okay, so Stefan, are you in the audience? You are. So if you'll come up to the podium, and I will join you down there at the podium. Thank you. Costa Mesa committed to the community, and so we are pleased to present you with this resolution number 1903 from the Costa Mesa Planning Commission. A lot of whereases, but they all recognize their contributions to the city, and be it resolved that the Costa Mesa Planning Commission hereby commends and thanks Stefan Andranian for his service on the Planning Commission this 11th day of February 2019. Stefan, it gives me great pleasure to give you this resolution. Again, Chairman Andranian, thank you very much for your service, and enjoy your free time. Okay, this brings us to public comment. To ensure fair and equal treatment to all who appear before the Planning Commission and to expedite city business, speakers may be limited to 3 minutes during public comment to speak on any item within the Planning Commission's jurisdiction, but is not on the agenda this evening. We can extend can't extend time for good cause if the chair and a majority of the commission votes to do so. So are there anybody here that wants to speak during public comment tonight? Yes, Ms. Spadoni. And then you don't have to, but if you at least provide your name for the record over the mic or fill out one of these cards, that would be great. Not required, but would appreciate it. Thank you.
Okay, well, since you already gave my name, I guess I'll have to fill out a card. My question was this, is that during the nominations that there were no public comments, and I would actually like to make a comment about the nominations, and one would be that I think you should take in attendance as a major issue. And since the co-chairman seems to have a number of absences compared to the other members, it would seem that should have been taken into consideration for optimum efficiency of the commission. And the other thing I'd like to mention is, I know you have a sober living issue coming up later. I'm not commenting on that particular issue, but I am commenting on a public information request that I put in. I put in a request asking for how many sober livings could be contained within an R1 and an R2 area, and I was told that those numbers were not available. However, in a testimony in a previous court, a recent court case, they quoted a number theoretically. So I'm just wondering if the Planning Commission knows any of these numbers, how many of sober livings in these 650 feet can the city hold in the R1 and the R2? It seems like it would be a very simple question to answer with an engineer and a slide rule and a little round swatch and a map. But I think the residents need to have that information so that they can make some comparisons to what's going on, not only in the court, but with all the litigation and all the cases. So if the city doesn't know how many sober livings we can hold, I really question that we should be entering into the litigation with not all the information up front. Thank you.
Thank you. And I would ask, I think that's a reasonable request, maybe if staff could, maybe over the next meeting or two, bring back that kind of comparison that she's asking for, unless we can't do it for some reason.
We'd be happy to do that, Mr. Chairman.
Okay, thank you. Yes, ma'am.
So whatever you do, do not turn on the air conditioner tonight. Thank you, because it's freezing. And also a shout out to Mr. Andranian. I'd like to say that I really appreciated the last 4 years. If you made a phone call to Mr. Andranian about an issue on the Planning Commission, he was back to you within 24 hours, and I really appreciate that. Just saying. So now he doesn't have to answer me. But anyway, so tonight, driving over here, I just magically found another sober living house that I didn't know about by accident. And today I got a phone call, and I would like to compliment Ms. Woods and Mr. Zeke, because you were the only two planning commissioners that listened to the residents about 1989 Orange Avenue. I believe it is a new sober living house. The residents have been calling me and asking me, what do we do, what do we do? And you know, we got up and we told you, we asked you not to let them put in that extra bathroom, and that they were going to make the office into a bedroom. And we said that, and of course, we were totally ignored, except for you two. And Mr. Zeke, you were brand new on the Planning Commission, so I appreciate that you listened to the residents last night. We sort of know what we're talking about on certain issues, although you completely ignore us most of the time. And some things have come up lately where owners of sober living houses are intimidating residents that are involved in court cases. And since I can't get a response from the police, I ended up calling the Attorney General's Office of the State of California. And if you harass someone that is involved in these cases, it's a criminal offense. And when you do it involving the federal case that's going on with Yellowstone, et cetera, that's a federal, you are breaking a federal law. And if it's a state level, you are breaking a state law. And so I think the police need to help the residents that are involved in these cases. I think we need protection. And one more thing, if someone throws a bottle over a fence and hits a neighbor that is protesting a sober living, that is a weapon. If I throw a bottle at a policeman, that's a weapon. Why isn't it a weapon when a sober living resident throws a bottle over a fence at a neighbor? Thank you.
Thank you. Any other member of the public wish to speak during public comment? Okay, thank you. Seeing none, I'll close public comment. And well, it takes us to Planning Commissioner comments and suggestions, and Commissioner Colbert, we'll start with you.
No comment.
Okay, thank you. Commissioner Zick.
Nothing tonight. Thank you, Mr. Chairman.
Commissioner Woods.
I'm honored to serve the Planning Commission again for another 2 years, and as always, I'm always available for a phone call or a chat, so please do. Thank you.
Vice Chair Harlan.
Thank you, Mr. Chair. I just wanted to welcome back again Commissioner Zick and Commissioner Navarro-Woods. Thankfully, it was not a long absence. And welcome Commissioner Colbert. I had a brief chance to spend some time with him this weekend, and I'm looking forward to serving with him the next 2 years.
Okay, great. And I just have a few things. I want to, again, congratulate Commissioner Zick and Commissioner Woods. I'm really very happy that you're back on the commission. I enjoyed working with you the last 6 months and with you the last 2 years. And Commissioner Colbert, I'm really looking forward to your perspective, the planning expertise that you bring to the table. So I'm very excited about your appointment. Ms. Parker, I will get you my cell phone number. I will return your calls. I don't know if you have it or not, but I will get it to you so you can call me if you need to. I just want to thank also my commissioners for the nomination to chair. It's a high honor for me, and I will try not to let you down and try to serve the public as best I can. I had a really interesting opportunity this morning to do a ride-along with Senior Code Enforcement Officer Mike Brumbaugh and Muriel Ullman, who kind of do daily early morning sweeps. I don't want to call them sweeps, but just make contact with the homeless population that we have in Costa Mesa. And I must say that there's a side, unless you're really looking, there's a side of the community that most people don't see. And these folks, a lot of these folks are really sweet people. They just either are dealt bad cards or they have psychological issues going on. Some have some substance abuse issues. But I mention this because I really want to compliment Officer Brumbaugh and Muriel for the way they engage these people and make contact and treat them with dignity and treat them with respect, ask them how they're doing, point out to them when they are violating ordinances so they don't get in trouble. They can kind of move along or clean up where they are. Muriel does a great job providing them with information about services that they can take advantage of. A lot of them don't want that, but some do. And so Mike rolls out at 5 a.m. every morning to kind of do that circuit, and often he does it solo, and that's not a safe position to be in sometimes. So I just wanted to give them a shout out for the hard work they're doing and really good work they're doing in our community. So those are my comments for this evening. Which brings us to the consent calendar. All matters listed under the consent calendar are considered to be routine and will be acted upon in one motion. There will be no separate discussion of these items unless members of the Planning Commission staff or the public request specific items to be discussed and are removed from the consent calendar for discussion. Items removed from the consent calendar will be discussed and voted upon immediately following Planning Commission action on the remainder of the consent calendar. Members of the public who wish to discuss consent calendar items should come forward to the microphone upon invitation of the chair. We just have minutes from the January 28 meeting on the consent calendar tonight. Does anybody wish to pull those from the public or any of the commissioners? Okay. Seeing none, is there a motion? Commissioner Zick.
Move the item.
Motion by Commissioner Zick.
I'll second.
Seconded by Vice Chair Harlan. Call for the question.
That motion carried 5-0.
Great, thank you very much. And brings us to public hearings. Public hearing number 1, Julie, please.
Public hearing item number 1, conditional use permit PA-17-10 to operate a sober living facility housing up to 45 adults in 5 units, including an appeal of the denial of a request for reasonable accommodation for relief from certain land use requirements of the zoning code, operated by the Ohio House at 115 East Wilson Street. This is a call to report any ex parte communications.
Commissioners, any ex parte communications to report? Okay, seeing none, Ms. Bowens-Clean and Ms. Lee.
Good evening, Mr. Chairman, Mr. Vice Chairman, and the rest of the Commission. As you heard from the Chair, my name is Willa Bowens-Clean. I'm the Zoning Administrator, and I'm here to present conditional use permit PA-1710 for 115 East Wilson Street, Units A through E. As you know, before we start this hearing, I'd like to provide some background information regarding sober living homes and licensed residential treatment facilities. The City of Costa Mesa experienced a significant increase in sober living homes several years ago. These homes generated a number of complaints regarding secondhand smoke, overcrowding, parking, noise, and impacts to the character of the neighborhoods. Under state and federal law, persons recovering from addictions to drugs and alcohol are considered disabled. The Federal Fair Housing Act amendments and the California Fair Housing Act prohibit the enforcement of zoning ordinances that would discriminate against equal housing opportunities for persons with disabilities. This means that the city is very limited in its abilities to take actions that would treat residents who are disabled differently from residents who are not disabled. State housing law sets forth occupancy standards for residential units. These standards are very minimal, meaning the typical single-family detached home in Costa Mesa could accommodate more than 20 people under state law. The city is not allowed to impose occupancy restrictions that are more stringent than those found in state law. However, the city's housing element does include standards for overcrowding, and we are reviewing group home applications for consistency with that standard. The Lanterman Act requires cities to treat state-licensed residential care facilities serving up to 6 residents as a residential use. These facilities are exempt from any city regulations that do not apply to all other residential uses in the same zone. So in response, the city carefully crafted regulations that respect federal and state laws, protecting the rights of the disabled while also protecting the quality of life in the city's residential neighborhoods. The city recognizes that sober living homes do provide a benefit to the community in that they offer persons recovering from addiction the opportunity to live in a comfortable residential environment. However, these facilities are often dissimilar to other households and neighborhoods in that they house all adults. The residents tend to live in the home for a relatively short period of time and often don't establish ties in the community. The facilities do not operate as single housekeeping units in that the residents generally have no say about who lives in the facility, and the number of occupants, while consistent with state housing law, is often higher than the typical household size in Costa Mesa, creating additional demands on city infrastructure and parking. For these reasons, the city decided to impose a separation requirement between facilities to avoid an overconcentration of sober living homes in any neighborhood. Not only does this standard preserve the character of the city's neighborhoods, it ensures that the needs of the disabled are addressed by allowing them to live in homes in traditional neighborhoods as opposed to a more institutional setting that might result if sober living homes were clustered in the same area. The city requires any sober living home to be at least 650 feet from any property that contains a sober home, group home, sober living home, or state-licensed drug and alcohol treatment facility. Sober living homes and licensed residential treatment facilities are limited to 6 residents plus a house manager in single-family zones. Facilities licensed by the state to serve 6 or fewer residents are exempt from city regulation other than those regulations that apply generally to all other dwellings. Facilities that are not licensed must obtain a special use permit from the city. In multifamily zones, facilities serving more than 6 residents require approval of a conditional use permit by the city, whether or not they have been licensed by the state. Operators of facilities that are not licensed by the state are required to obtain an operator's permit from the city. As part of this permit, the city requires the operator and staff to undergo a live scan background check. In addition, a house manager or staff member must be present at all times, and any resident who is evicted or whose residency is involuntarily terminated must be offered transportation to the resident's permanent address. A sober living home is not allowed to provide treatment services, counseling, or other services without a license from the State Department of Health Care Services. The application before you tonight involves sober living facilities. In May 2017, the City Council adopted an ordinance modifying some of the existing standards for group homes and licensed residential treatment facilities. Now, the city is required to provide notice of public hearings for these facilities to residents and tenants within 500 feet of the site, in addition to property owners. Such notice was provided for the hearing tonight. The findings required to approve a reasonable accommodation were modified slightly. In addition, applicants are required to ensure operations comply with all provisions of the California Vehicle Code, such as those addressing parking and stopping. Operators must comply with additional requirements intended to minimize the chance for evicted residents to become homeless if the resident is unwilling to return home. The operator must contact the county and the city's network for homeless solutions to determine if services are available for the resident and to provide transportation to a facility that has a bed available. Of course, the operator cannot compel a resident to take advantage of the transportation. This application before you is Conditional Use Permit PA 1710, a request to operate a sober living facility housing up to 35 gender-specific adults with up to 10 live-in managers in a 5-unit common interest development. The applicant also submitted a request for reasonable accommodation to allow this facility to be within 550 feet of another property that contains a sober living facility and for relief from other land use requirements. The application for accommodation was denied, and the applicant subsequently appealed that decision to the Planning Commission. The subject properties are contiguous and operated as a single facility, so staff has prepared a single staff report for these 5 units. The site currently operates as a sober living facility. Staff believes the use was established in early 2016. The site houses up to 45 residents. There is 1 unit on each of the 5 parcels at this facility, held together as a common interest development by a common lot at the front of the property. There has been 1 complaint to code enforcement expressing concern with the number of people and type of activity occurring within the 5 group homes. The complainant also expressed concern with the amount of trash and cigarette butts, the poor condition of the alley, and homeless and other people hanging out in the alley. Additionally, there have been a total of 14 calls for service in the last 3 years, 8 of which are attributable to the property. These calls for service related primarily to theft and disturbances, with 2 calls for medical aid. Staff also received 3 emails in response to the notice for this meeting to protest the project. The applicant requested, and the Director of Development Services denied, a request for a reasonable accommodation to allow this facility to deviate from certain standards set forth in the Costa Mesa Zoning Code. The hearing tonight includes the applicant's appeal of the Director's decision. For a little background, this development was approved as a 5-unit common interest development in 2003. Each individual lot is separately owned. However, each individual owner is also part owner of a commonly held lot and is part of a joint homeowners association. Each parcel is developed with a 2-bedroom, 2-story, 4-bedroom, 3-bath, single-family home. Each unit includes a 2-car garage with a driveway leading to the garage, providing adequate space for 2 vehicles. All 5 garages and driveways are accessed from a public alley. All units are currently operating as a single facility. And as previously stated, staff believes this facility was established in early 2016. So this is a quick view of the floor plan, which is typical. The last unit, Unit E, is a reverse of this, but otherwise the majority of the bedrooms are upstairs with 1 bedroom downstairs, 1 bathroom downstairs, and the attached garage. This is an exterior elevation of the property. And as I said, the property was approved in 2003. It conforms with current development standards for this type of development in this zone. However, at the time and continues, the lot is non-conforming for minimum width standards. The subject property is located on East Wilson Street between Newport Boulevard and Eldon Avenue. It's located approximately 550 feet from the sober living facility existing at 165 East Wilson Street, which was approved under PA 1603. That facility at 165 East Wilson Street serves 10 male residents plus 1 live-in house manager. Separation conflicts are created by a variety of items as listed here. They could be a state licensed treatment facility with 6 or fewer. They could be a sober living state licensed and straight licensed treatment facilities where we've issued a CUP to serve more than 6 adults. sober living facilities serving up to 6 adults for which the city has issued a special use permit, or also state licensed facilities or sober living homes which require but have not obtained a conditional use permit or a special use permit and are operating in violation of city zoning regulation. As I stated earlier, there is one city-approved facility within a 650-foot radius that's located at 165 East Wilson Street. It's a sober living facility, serves 7 male residents, and it was approved under PA 1603. Other facilities within the radius are facilities at 125 and 131 East Wilson Street. Each serve 7 or more residents and are in violation of the municipal code. They had applied for conditional use permits for both facilities but were denied in April 2018, but the uses continued. Consequently, there are active code enforcement cases on both properties. Additionally, there is a facility operating at 114 Albert Place. 2 citations have been issued by code enforcement for operating in violation of the municipal code. As stated earlier, the applicant has requested a reasonable accommodation to allow this facility to be located within 650 feet of a property containing a sober living or state licensed facility. In addition, the applicant requested that the city consider the residents of this facility to be a single housekeeping unit and to grandfather this facility, stating that it was in place before ordinance number 15-11 was adopted. However, no actual date when the facility was established has ever been forwarded to planning staff. Based on the request by the applicant, the director determined that not all of the required findings to approve the request for reasonable accommodation could be made. The request for accommodation was denied based on the following reasons. Number 1, the director found that approval of this request is not necessary to allow the disabled to use a dwelling in Costa Mesa, although it is necessary to allow the disabled to live in these particular units. There was no justification provided to support the request to grandfather the facility or consider the residents of the facility to be a single housekeeping unit. Indeed, the Costa Mesa Municipal Code includes amortization provisions for group homes that were in operation at the time the Ordinance 1511 was adopted. All such homes, however, were required to come into compliance within 1 year. The residents do not live as a single housekeeping unit as defined by the municipal code, in that they have no control over who else resides at the facility. Rent is collected from each resident, expenses are not shared, and residency tends to be transient. Approval of the request to consider the residents of this facility to be a single housekeeping unit or to otherwise exempt this facility from regulation would be contrary to the purposes and intent of Ordinance 15-11. Second, the applicant did not demonstrate that the accommodation is consistent with surrounding uses in scale and intensity. As stated earlier, the subject facility does not operate as a single housekeeping unit or even 5 single housekeeping units, making it dissimilar to the composition of households on surrounding properties. The facility is occupied solely by adults at a higher occupancy than is typical in Costa Mesa. Each resident is allowed to keep a car on the property, providing opportunities for parking conflicts with owners of nearby properties who also rely on on-street parking. The city's intent in adopting its group home regulations was to ensure an overconcentration of group homes did not occur in any neighborhood. This facility would contribute to overconcentration, given that it is located within 550 feet of another sober living home. Number 3, the applicant did not demonstrate that accommodation is necessary to allow persons with disabilities an equal opportunity to live in a residential setting. The city has received applications for 65 sober living homes and 11 licensed treatment facilities that are subject to compliance with ordinance numbers 14-13 and 15-11. 12 sober living homes serving 6 or fewer residents have been approved by the city, and 2 sober living homes serving 7 or more residents have also been approved. In addition, there are 74 state-licensed drug and alcohol residential care facilities in Costa Mesa that are exempt from city regulation or have already obtained the required conditional use permit. No evidence has been submitted to indicate that the number of sober living homes and drug and alcohol residential care facilities existing or potentially allowed in compliance with the city's standards is inadequate. Lastly, the director was unable to find that the approval of this accommodation would not alter the city's zoning program. The city's regulations seek to ensure that disabled persons recovering from addiction can reside in a comfortable residential environment versus in an institutional setting. The city determined that housing inordinately large numbers of unrelated adults in a single dwelling or congregating sober living home in close proximity to each other does not provide the disabled with an opportunity to live in normal residential surroundings, but rather places them into living environments bearing more in common with the types of institutional, campus, dormitory living that the state and federal laws were designed to provide relief from for disabled persons. The city has determined that a separation of 650 feet is appropriate between sober living and licensed treatment facilities. The subject property is 550 feet from a sober living facility approved under PA 1603. Therefore, approval of this request will create an overconcentration of sober living facilities in this neighborhood. If the denial of the reasonable accommodation is upheld, the facilities will not be in compliance with the city's separation standards unless the Planning Commission makes a finding that approval of one or both of these CUPs, approval of the CUP will not result in an overconcentration of such units in this neighborhood. The Commission must make findings to approve a conditional use permit. While some of these findings can be made, key findings cannot. First, the Planning Commission must find that the sober living facility would provide a comfortable living environment that will enhance the opportunity for disabled persons, including recovering addicts, to be successful in their programs. In adopting its regulations, the City Council sought to ensure that disabled persons recovering from addiction have the opportunity to reside in a comfortable residential environment versus an institutional setting. The city determined that housing inordinately large numbers of unrelated adults in a single dwelling or congregating sober living home in close proximity to each other does not provide the disabled with an opportunity to live in normal residential surroundings, but rather places them into living environments bearing more in common with the types of institutional, campus, dormitory living that the state and federal laws were designed to provide relief from for disabled persons. Approval of this CUP to allow a sober living facility to serve up to 45 residents would not provide a comfortable living environment to enhance the potential success of those in recovery. Staff notes that the lot width is narrower than current code requires, so it is non-conforming with current code requirements in that respect, and especially based on the number of rooms in the units and the number of residents, the facility may potentially be overcrowded per guidance provided in the city's housing element. Consequently, the intensity of the use would not contribute to a comfortable residential environment. The Commission must also find that the sober living facility would limit the secondary impacts related to noise, traffic, and parking to the extent reasonable. Existing on site is only 20 parking spaces to serve the 40 to 45 adults residing on the site. 8 calls for service attributable to the property, 8 police calls for service attributable to the property, and 1 code enforcement complaint involving trash and cigarettes in the abutting public alley in the past 3 years have been received. Consequently, the intensity of the use generates secondary impacts on the neighborhood. The code requires Commission find that the sober living facility would be compatible with the residential character of the surrounding neighborhood. The municipal code specifically requires a separation of 650 feet between group homes serving those in recovery from drug and alcohol addiction to avoid an overconcentration of such facilities in any neighborhood. The clustering of such facilities could lead to an institutional feel in a neighborhood. The city's regulations are consistent with the goals of the state and local laws that seek to allow recovery in residential settings. There is a licensed facility serving 10 male residents plus 1 live-in manager within 550 feet of the subject property. Therefore, approval of this CUP would contribute to overconcentration of sober living facilities in this neighborhood. Subject property is non-conforming with respect to lot width. The units would also be overcrowded per the guidance in the city's housing element. Therefore, the proposed intensity of use is incompatible with the residential character of the neighborhood. The code also requires the commission determine that the group home is at least 650 feet from any property that contains a group home, sober living home, or state-licensed drug and alcohol facility. As noted before, this facility is within approximately 550 feet of a sober living facility serving 10 residents with a live-in manager. Based on denial of a reasonable accommodation, the facility does not comply with the city's adopted standards for separation between group homes. Approval would result in an overconcentration of sober living facilities in this neighborhood. Therefore, the findings required by the municipal code to approve the CUP cannot be made. The commission must find that the proposed use is substantially compatible with developments in the same general area and would not be materially detrimental to other properties within the area. A licensed treatment facility serving up to 45 persons would not be substantially compatible with other developments in the general area. Given the proximity of the subject property to another licensed facility, approval of this CUP would result in an overconcentration of such facilities in this neighborhood. Subject property is non-conforming with respect to lot width. Approval would allow residents to live in overcrowded conditions. Therefore, this finding cannot be made. A finding that granting the conditional use permit will not be materially detrimental to the health, safety, and general welfare of the public or otherwise injurious to property or improvements within the immediate neighborhood is also required to be made. City Council has determined that an overconcentration of sober living facilities would be detrimental to the residential character of the city's neighborhoods. The use of a parcel that is non-conforming with respect to lot width to house up to 45 adults in overcrowded conditions is contrary to the general plan's goal to maintain the character of residential neighborhoods. Consequently, staff recommends that the Planning Commission adopt a resolution to uphold the director's decision to deny a reasonable accommodation to allow the facility to deviate from various land use standards, including the separation criteria, and to deny conditional use permit PA 1710. Staff notes for the record that the resolution was reviewed and approved as to form by the City Attorney's Office, and staff would like to note that we are available for any questions you might have, as well as Captain Glass is in the audience as well. Thank you.
Thank you, Ms. Bowens-Clean. Very thorough report. I appreciate that very much. Commissioners, any questions of staff?
Mr. Chairman.
Commissioner Zick.
A couple questions. So we're looking at one application. I'm curious about the property ownership, the 5 units. Are they separately owned? I know they can be, but do they have separate owners or a single owner?
Commissioner Zick, there is one property owner who owns at least 2 of the units and is in a partnership with another owner, and there's at least one separate individual property owners. It's approximately 3 owners altogether.
So if all of this reasonable accommodation and CUP were approved and they were operating, and one of those 5 property owners decided to sell their property and no longer have it function in the sober living role, would the CUP have to change at that point?
No, the conditional use permit runs with the land. They would have to comply with the requirements of the operator's permit, but the CUP itself would run with the land.
Okay. Another question. Is it possible that the reasonable accommodation could be approved, but the CUP still could not be approved based on certain findings?
Commissioner Zick, if I understand your question, it's if the reasonable accommodation were approved, could the CUP still be denied on the basis of other findings? Yes, they can operate independently. They do have a connection to each other, specifically related to the separation conflict and all of the other zoning code requirements that the reasonable accommodation request asks us to override, essentially. They are connected in that way, but they can also operate independently.
So said another way, if this property was 700 feet away from the nearest licensed sober living home and reasonable accommodation wasn't in question, the approval of a CUP still could be denied.
That's correct.
Okay. So I am curious about the property that is at 165 East Wilson that was approved in 2016. Are you aware of the calls for service record for that property?
We are not.
Okay. And then I'm curious about the two properties that are immediately next door to this application, the one at 125 and the one at 131. Your staff report on page 7 indicates that CUPs for those two properties were denied and that there is still an active code enforcement case. I'm thinking in my mind that whether they were denied or approved or had code compliance enforcement cases against them is sort of irrelevant based on the reliance on this previously approved operation at 165 East Wilson. Seems like it's a kind of an insult to injury situation as opposed to a substantive fact.
That is correct. The separation conflict is 165 East Wilson.
Okay. And then I was curious about two things that were stated in the staff report, one on page 4, one on page 5. And what it was saying is that if the Planning Commission wished to approve the CUP, the applicant would be required to submit complete information. Similarly, if the Planning Commission were to approve the CUP, in order for the operator's permit to be issued, certain information would have to be submitted there. And I can't help but wonder, at this stage of the game, you still don't have the information that you would have needed to process the applications had it not been denied. Okay?
That's correct, Commissioner Zick.
That's it for now, Mr. Chairman. Thank you.
Okay, thank you. Commissioners, any questions of staff? I have just a few. I'm going to go back to the description of the property. And it basically says the development was approved as a 5-unit common interest development in 2003. Each individual lot owner is a part owner of a commonly held lot. So my first question is, are the individual lots that those people own, do they have their own APN number?
Yes, they do.
And so absent a lot that ties it all together, a common interest lot, this would not be a common interest development.
That's correct.
Okay. Okay. Sequencing. Do we have, whether it's a regulatory regime or an administrative regime, a preference with respect to an applicant first seeking a CUP and then an operator's permit, or first having all the operator's permit information in before they file for a CUP? Or is it just kind of how it goes?
So from a sequencing perspective, the conditional use permit is considered first. The operator's permit is something that occurs after the conditional use permit is decided on. However, typically as a matter of practice, the information that is required for an operator's permit is typically submitted at the same time with a conditional use permit application. Not always the case, but that's typical.
Okay, thank you, Ms. Lee. And then Ms. Bowens-Colleen, on the overcrowding in our housing element defined, do most jurisdictions define overcrowding in their housing elements that you know of?
I would say that most jurisdictions have some reference to overcrowding as a consideration as part of their housing element. Different cities address the issue in different levels of specificity. In Costa Mesa, we did it through a general plan guidance in the housing element.
Okay. And in terms of communicating with the applicant with respect to trying to get some clarity with respect to the care and supervision, whether or not that would not be occurring in all 5 units or only some. To what extent have we communicated with the applicant asking for those clarifications with that respect and also with the operator's permit information?
The application that was submitted by the applicant includes a checklist to indicate whether or not they're providing that kind of service. And they indicate that they were not providing that service as part of the checklist of the application.
So they did not?
They indicated they were not providing extra care and services, just a sober living facility.
Okay. Okay. I think that does it for me for now. Commissioners, no questions? Okay. I will open the public hearing and ask the applicant to come forward if they're here. Good evening, gentlemen. If you could state your names for the record, and off we'll go.
Good evening, Garrett Pueblo, representing Ohio House and Brandon.
Yeah, could we either pump the gain up on the mic a little bit, have it get
Can you hear me okay?
Yeah, but we're going to start getting a little bit of feedback, so maybe pull it down a little bit.
So, my name is Garrett Pueblo. I represent the applicants, and I have the principals behind the application here, Brandon and Ryan Stump. Introduce yourselves.
Ryan Stump, Chief Operating Officer, Ohio House.
Brandon Stump.
Okay, gentlemen, do you have any formal presentation you want to make, or well, obviously you're willing to answer questions, hopefully?
Yeah, we're here to answer questions. We wanted to kind of correct a few errors that we saw, nothing too big, but some material discrepancies in terms of the operation and what we saw in the application. The first being that as to one of the units, we've actually been there since 2012. And so all 5 of these units actually do predate the enactment of Ordinance 1511, which helps the reasonable accommodation, the grandfathering request make a little more sense. Based on the presentation we saw here today, it wouldn't really make sense to ask to be grandfathered in if we actually did begin operating in 2016. But we've actually been there since about 2012. The other thing is, we'd like to clarify regarding our residents and their ownership or operation of vehicles and their ability to bring vehicles to these properties. We actually have a pretty strict vetting process through which we ask our residents to apply to be able to bring a car to the property. The priority is given to individuals who either are in school or are currently employed and need the car. On average, I think our current car ownership rate, well, not ownership, but the number of residents we allow to have cars while residing at these properties is about 25%. So you're looking at about a total amongst all 5 properties of about 10 to 12 cars at any one time. And we do think that that is in conformity with your average household on the block to have about 2-3 cars per home. Those were the real discrepancies I saw. We're here to answer any questions and hopefully can fill in some gaps as to what the omissions were in the application. There are things in these applications that are just inherently impossible to answer. And so, when we get down to the nitty-gritty, there might be certain things that an applicant, in our estimation, can never provide with satisfaction to either the Planning Commission or the Council. And I think we can discuss some of that. As to the density or I guess, the density of the usage of each individual property, I mean, we're looking at 2,400 square foot homes, and on average are housing about 6 individuals. I understand the application asks for up to 45, which is 7 plus the house managers, but the actual occupancy rate is almost consistently about 6 individuals per home. We're never at a 100% occupancy rate. So when you look at a 2,400 square foot, 4-bedroom home, we'd argue that we are relatively compatible with your average home on the block. So yeah, just those were some clarifications, some points we wanted to make up front, but we're happy to answer any questions and be as transparent as possible during this process.
Thank you, sir. Commissioners, any questions for the applicant?
Mr. Chairman.
Commissioner Zick.
So I've got 2, and I want to slip a question into staff as well. And so the first question is for staff. Based on what the operator is saying, that the occupancy is less than the number in the staff report. The question I have is, so if there weren't 45 people, there were 30 people, could the CUP be based on that occupancy limit?
I think that it comes down to what the applicant is requesting. Our understanding is that they are requesting 7 or more with live-in house managers, and so if they modify their application, for example, to include 6 or fewer, then we would review that. At the end of the day, I believe it's still a conditional use permit that would come before this body.
Okay, thank you. So that leads me to an obvious question to you. So the numbers that are in our staff report, I'm assuming, are based on what it is that you have applied for. So if you're indicating that the occupancy is actually less than this, then are you indicating that maybe you've over-applied?
Well, that's a very good question. I think not that we over-applied, but I think when they were going through the application process, looking at other applicants in the community, they wanted to get what would be the maximum number to comfortably fit in that home. But during this process and during this reasonable accommodation appeal hearing and request, if it were something that would help the Planning Commission move towards a possible approval of a CUP, we would absolutely be willing to reduce those numbers to what our actual occupancy rate is. So, I mean, it's something that I think during the reasonable accommodation process there has to be some give and take. And if there was a number somewhere in the middle that would allow the approval of CUP, it's something that we would absolutely consider. But it's not that we over-applied. It's that when you're going through the process, you look at the square footage of the home and how many individuals you can comfortably have living there, and that's what you tend to put on the application. And that leaves room for this conversation.
Okay. I've got another question for you, but the predicate question to staff. The 650-foot separation distance, do you recall or have any insight into how that figure was established?
It was established before my tenure at the city, so I'm going to talk a little about my understanding and then ask our attorney's office to weigh in if they could. It's my understanding that the separation of 650 feet was established at least partially with the idea that one sober living facility or state licensed drug and alcohol treatment facility on an average block would have been a reasonable distance, and that that was the primary basis for it.
Okay, thank you. So my question to you, you indicate you've been operating since 2012.
That's correct.
The city's ordinance was in 2015.
Correct.
And the 650-foot distance obviously was a part of that. And so I'm wondering, and you don't have to answer the question if you don't have an answer or don't want to, but what I'm wondering is, to what extent were you involved and objected or inputted to the city process that established that ordinance that potentially, because of it, put your operation at risk?
And I imagine that question is directed to the applicants. We weren't directly involved in that process. You know, we were quietly operating there for about 3.5, 4 years at the time the ordinance came into effect, and hope to continue to do so and go through this permitting process and be awarded the permit. So that's the best I could answer that question.
Were you aware that the city was putting an ordinance in place in 2015 that affected your operation?
Oh, you guys aware? You can answer the question if you like. Yes, we were aware.
Okay. Thank you, Mr. Chairman.
Commissioners, any questions? Commissioner Woods.
Hi, I have a couple. Just point of clarification. So right now you're housing 6 individuals in recovery per home. Is that correct?
Approximately, yes.
Approximately. So is that your average? Do some homes have more? Do some homes have less?
On average, maximum capacity is about 6 plus a house manager. It's not uncommon to have less, and it's far less common to exceed the 6.
Okay.
Just given the number of rooms in the homes. But on average, you're looking at about 6 individuals. But given the purpose of the homes and the mission of both the homes and the individuals coming there, there is a turnover rate. And so you do see, oftentimes you'll have 3 individuals in a home. And the idea is to get the house back to what is considered to be a safe and comfortable occupancy level so that the individuals in each home have that kind of camaraderie and communal environment, which kind of goes right into our request that we be, under the reasonable accommodation request, treated as a single housekeeping unit. I digress from your question, but there is more to it than simply getting as many people in a house as you can.
Okay. Does each unit have its own house manager?
Yes.
Okay. And there's a really nice, I noticed in the pictures, you guys have really nice patio spaces. I live not too far away, and I used to go to the businesses nearby. I don't anymore, and I'll tell you why in a minute. But often, there's a lot of men congregated in the alley. They're smoking and not doing a whole lot. And
Right.
I understand, right? What are your sort of house rules in terms of that? I mean, there's a really nice patio space. I'm surprised that they're not using their patio space a little bit more often, like some other homeowners do. And why so much congregation in the alley?
I'm glad you bring that up. You know, when we heard about these calls for service, it was brought to my attention that, there's a Circle K nearby, and there often are large numbers of individuals, homeless, congregating there. Many of the calls to service to these properties were actually initiated by our side because of the congregation of individuals in the alley and physically on our property. So, I mean, to the extent we have statistics here and numbers, it would, when read in the context of this hearing, might indicate that there have been 18 calls to service to these properties from the community or from individuals in the homes for a variety of reasons. I think that if we were to actually look at those calls, the vast majority of them are from us actually trying to address some of those same issues. To the extent you're referring to individuals from our homes smoking in the alleys, it's hard to know without knowing exactly who it is you were looking at and where they
Sure.
reside.
Yeah.
But I will tell you that many of our residents work in the community.
Okay, I appreciate that,
And
but
go
I
to
really
school.
wanted to get back to my initial question. What are your house rules
The house rules,
regarding
sure.
congregating in the front yard? Is that allowed, or would you prefer them to be in the patio, where they may be just acting?
No, we absolutely prefer them to be on the patio. I'd be lying if I'm standing up here saying we're perfect and no one ever congregates out front. Our goal is to absolutely have them congregate in the patio area, and oftentimes that's exactly what they are doing. Our house managers are responsible to hold them accountable to that. But in terms of the house rules, all the clients, they must be in school, working full-time, or in therapy. So most of the day is filled with one of those 3, if not all 3 of those things.
Okay. Okay. In your letter, you state that you often do service work for the community. Can you share some of the service work that you do for our community?
Yeah. Oftentimes volunteering at the local soup kitchen on 19th Street, right here.
Okay.
So that is actually required in your first 30 days that you volunteer there at least once. Oftentimes those guys are going once per week. And then we also volunteer outside of Costa Mesa, but still local in the community with the animal shelter in Huntington Beach, as well as the LA Mission up in LA County.
Okay. Okay, that's all my questions for now. Thank you.
Thank you.
Commissioners? Commissioner Colbert.
Mr. Stump, I didn't catch your name, I'm sorry.
Ryan Stump.
Ryan Stump. Mr. Stump, what is the application process for an individual applying to be within your residence at the Ohio House?
It is mostly verbal. They work with our admissions team. We have an admissions team that vets them through a phone call where it's individualized with that potential resident, our admissions team, and then we also work with their families or those who are financially responsible for that individual to discuss that with them as well.
And what is the success rate for individuals who live within the Ohio House as in engaging within the community as far as like employment or reintegration within the community?
What was the end of your question?
Reintegration within the community as far as like success rates of employment or leaving?
I appreciate the question. My name is Brandon. I'm Ryan's brother. Started the company. And before I answer your question, I just want to say to everyone up here asking questions, we appreciate the questions. Throughout this process of communicating with the city since 2015, I haven't taken one phone call asking me one single question. I've actually sent emails, I've made phone calls, I've left voice messages trying to build a relationship with the city's planning commission, trying to have a dialogue of communication, and all I get is emails and applications online, no direct communication. So it's nice, it's refreshing to have a question and to hear people that are actually interested in what it is we do. It's also very interesting to go anywhere and defend what the Ohio House is. I've never in my life had to defend what I do. So it's interesting. Going back to your question, the success rate. Anyone that gives you a mathematical success rate equation, please have them call me too, because I want to know what that is. I can tell you this. We've been operating since 2012. I got sober in 2010 when I flew out here to go through one of these centers. And I've been sober ever since. And when I started this deal in 2012 till to date, as an organization, we have celebrated over 600 years of sobriety. And I can go into great detail of what 1 year of sobriety can do, because it did it for me, and it did it for this city, and it did it for this world. What the Ohio House is doing is changing the world. And if you would like to learn more about our rules, our success rate, our operations, we have an open door policy. You can come by any time. I'll eat lunch with you. I'll take you to the houses. I'll talk to you about the programs. You can talk to our clients. You can talk to our alumni. What are we doing for the community? We've had well, first of all, Ryan stated, you have to be in order
Mr.
to
Stump,
live it.
not to cut you off, that wasn't my question. I wasn't really interested in the community aspects of it, but I appreciate that engagement. But I wanted to talk about the transient aspects of the property. You did state that the property, or I believe your council stated that the property, and that's why I was asking about how often people are integrated back into the community. I noticed that within the application that there was an average of 7 months that individuals stay within the community. So is that pretty consistent still?
Yeah, it's a long length of stay. We have a great success rate. They stay for about 7.5 months, and then they leave our program, and they're ready to integrate back into the real world on their own dime, doing their own thing, living alone. Some of them stay locally, yes. Some of them create jobs and create businesses and employ civil people
Okay.
from the city.
And you said you've been operating since 2012, is that correct? Okay. And so in 2012, were you aware that there was another property at 165 East Wilson Street? No? When did you become?
You want to go ahead? I just had a point of clarification. On the application, it was indicated that the average length of stay at these properties is 7 months, but we're not representing that the average length of stay in the community is 7 months. Many of the individuals do choose to stay in Costa Mesa thereafter, so I just wanted to clarify as between the length of stay at the home and in the city of Costa Mesa.
Thank you.
I'm sorry, and I didn't mean to interrupt. What was the question again?
I was asking him, was he aware of the property at 165?
No. Oh, no.
No, okay. No more questions.
Okay, thank you, Commissioner Colbert. Vice Chair, you have any questions? Okay, I have a few. Not to nitpick this, but your council said that you established about 2012 was the word I wrote down. I'm trying to pin down when you first started operating your first house in this location.
Yeah, I'll tell you the day.
Sure.
The day I pulled up to 115 East Wilson Unit E with a for rent sign outside of it and walked in and met the property owner and told him that this is what I'm doing. I have this little program called the Ohio House, and I've been in business for about 6 months, and I had one other house. And when I saw it, I saw a perfect opportunity to do what I wanted to do in it, so I leased it. And when I looked at
It's just, sir, I just need to have you be at the microphone, that's all.
Oh, you can't hear me?
Well, but I need the audio guys be able to pick you up too.
Gotcha.
All right, thank you.
Audio. So, yeah, when I pulled up to that property, I met the homeowner there, told him what I was going to do with it, and I leased it, and I've been there ever since. I also looked at the other 4 units that were next door to it, and I said, one day I'm going to own all of these homes.
Okay, and do you currently operate other houses in Costa Mesa apart from these 5?
We left a couple of them.
Yeah, we were operating at Torres Lane, San Bernardino, and Joanne Street, but no longer.
So these are the only 5?
No, we have more in Costa Mesa.
Okay.
Which ones are left?
Tustin.
Oh, that's right.
And are those full? Do you have max occupancy in those?
We never operated max occupancy in any of our houses.
Okay. So is there a reasonable, is it reasonable to assume that your current residents, if one or more of the CUPs were denied, that they have other places to go, including your facility?
Well, it's a difficult question, Chairman, because when we get into that analysis, essentially what we get into is whether or not we have an ability to expand ever. Of course, when a business grows, you always have some sort of kind of growing pains, and to require that there be 100% occupancy across the board as a element of denying a conditional use permit or reasonable accommodation is kind of a catch-22. I mean, given the nature of the fact that individuals are coming to transition back into society,
Sure.
There's always going to be a time period when you're not, I mean, it's inherent in a transitional home that there's going to always be less than 100% occupancy. So to answer your question, yes, if we shut down one of the homes, could we take 2 of the guys and put them in a different home? 3 of the guys, sure. But that analysis doesn't really have a finish point to it, so it's tough to say.
Yeah, no, in my mind, what I'm trying to decide is we have a certain obligation to make sure that if we deny something like this, that we're not denying your residents an opportunity for shelter or a home somewhere within the city.
Right.
Okay. So let me ask you a question about house rules. I'm looking at our Ms. Vanderduzen's response to Mr. Poland's letter, and And this is a question that is tracking along the lines of a single housekeeping unit. Do your residents have any kind of say in who resides within the homes that you operate?
You guys want me to? I mean, to the extent that we listen to the residents and we communicate with the residents quite regularly, if there's someone who comes into the home that's not compatible, we find a more compatible location for them. And that's not just within our operation. We reach out to the community.
But original admission into the home, do the members get to interview the potential candidate and decide if they should or shouldn't be in there?
No, that would be highly unusual in a sober living environment.
Okay, thank you. I think that's it for me right now.
Mr. Chairman.
Commissioner Zick.
So I got two more questions for the applicant that have kind of come up, and I'm referring to the letter from Stephen Poland,
Right.
September 12, 2017. So on the first page of that letter, which is a staff report, page 45.
Thank you.
That's where you indicate that, I say you, are requesting the reasonable accommodation, wanting referring to the single housing unit and single family uses. My question isn't about that item. But on page 47, the second thing that you ask for is a waiver from the Costa Mesa Municipal Code requirements.
Right.
And when I look at the items in that letter, I just want to be clear. So when we have a requirement that says there's this occupancy limit and the house manager, and you can't exceed this number of occupants, you don't want to be held to that. When it says the group home has a house manager who resides in the home, 24-hour basis, responsible for day-to-day operations, you don't want to be held to that requirement either. But that's a question. I'm trying to ask that as a question.
First question? Because it's a compound question.
Okay.
So these kind of flow off of the first reasonable accommodation, which is to be considered a single housekeeping unit. The idea and legal theory behind this is that if we are in fact a single housekeeping unit, then these things shouldn't apply because none of these requirements would be applied to any other single housekeeping unit on the block. Taken in a vacuum as you are here, it doesn't seem to make sense that we would both come to the city and ask to let us stay and then simultaneously say we don't want any of your rules to apply to us. We would be happy to operate within some reasonable regulation, but as you read this letter drafted by Mr. Poland, those flow off of the request that we be treated as a single housekeeping unit. And if you had a single housekeeping unit, whether it be a nuclear family or an extended family, none of these requirements would apply. You couldn't say that you couldn't have more than six people in your extended family or something of that nature. So that was the idea behind this letter. So if we were to be treated as a single housekeeping unit, it would naturally follow that these couldn't necessarily apply to us. Now, that's not to say we wouldn't expect that there be some regulation.
So I understand your point and understand your perspective and your approach with that. The reason why I'm asking the question is because a couple of my fellow commissioners have asked you questions relative to house rules, something that I would think would be more informal. I don't think we have a Costa Mesa Municipal Code document that identifies specific house rules. And so it seemed as if you wouldn't be willing to be held to what the Costa Mesa Municipal Code requirements are, then to be held to house rules would kind of be, you might have the same philosophy about that as well. if I don't have house rules in my house, you shouldn't have to have them in your house, is what I'm kind of hearing you say.
Well, I would politely disagree, and I think courts have found that, in fact, it's quite normal for a house to have rules. Parents have curfews, they charge their parents rent, they might
Right.
limit smoking and talking and traffic and noise. And so the real thrust of this reasonable accommodation is that, is this the least restrictive means to accomplish a legitimate government interest? We would argue that it's not the least restrictive means. There are things already available contained within the Costa Mesa Municipal Code that could easily be enforced to go ahead and govern any of these things that we've heard that really form the basis of the denial, the traffic and the noise and the smoking. I read the emails that we received back here from local members of the community, and they were, I think they were very polite, and they were, the types of concerns that we hear time and time again. But again, there was nothing in any of them that tied any activity directly to any of the members of these homes or any of these exact property addresses. We hear concerns about smoking and noise and traffic, and that there are drug addicts in the community and that there are homeless people in the community. But if there was a real problem with any of these addresses, we could easily, the city of Costa Mesa could easily enforce their abatement laws and their nuisance abatement laws, gather the evidence that they have, and abate the nuisance like any other property without falling back on this, you're per se illegal.
Thank you. I appreciate that. I understand your response, and thank you for that. I also wanted to thank you, Brian, for your comments. I thought they were helpful. Appreciate your input. Thank you, Mr. Chairman.
Thank you. If there are no other further questions of the applicant? Commissioner Woods.
I have a comment, not a question.
Let's be careful about what we say, though. We haven't heard from the public yet.
Okay, I'll reserve my comment.
Thank you. Thank you, sirs, very much for your time and for your presentation. I will now invite the public to speak on this item. Please come to the podium. It would be great if you got in line. I know you don't like to stand in line, but it would be great if you could. Thank you.
Flo Martin, almost 52-year resident of Costa Mesa. Reasonable accommodation. Page 6 of the staff report says 1.3 to 1.5 persons per room. I live in a four-bedroom house, and the idea of 9 people living in that house makes me shiver. Page 7 of the staff report. Reasonable accommodation, quote unquote, flies in the face of 165 Wilson, 125 Wilson, and 131 East Wilson, and 114 Albert's Place. They're all flipping the proverbial finger at the city of Costa Mesa for not complying with the rules and regulations. And to quote Jim Righeimer, one of his favorite expressions on the dais was, "The reality of it is," or "the truth of the matter is," that the rise in petty crime and the upswing of sober living homes in Costa Mesa go hand in hand. My oldest son is a recovering alcoholic. He's been sober for close to 3 decades. He confided in me years ago that he stole petty theft from cars to support his addiction. My heart goes out to recovering addicts. My heart does not go out to the fire department deployments, and I read here on staff page 14, staff report, that in some neighborhoods, I protest that. It's not some, it is all neighborhoods. My family home is 0.7 miles away from the facility in question, a 6-minute bike ride or a 25-minute walk. In the past year, my neighborhood, which consists of a cul-de-sac with 10 homes, has had car theft, bike theft, and break-ins. The sober living home facility on East Wilson that's in question here would affect not just that neighborhood, but all neighborhoods in Costa Mesa. Thank you.
Thank you. Yes, ma'am, good evening.
My name is Barbara Ward. I am a landlord in the city of Costa Mesa.
Ma'am, if I could have you address the commission, because your voice is kind of going that way
Okay,
instead.
all right.
Thank you. And I stopped your time. You're good to go again.
I'm a landlord in the city of Costa Mesa since 1970. 30 years ago, I asked the commission for approval of 6 one-bedroom apartments on the halfway between Harbor and Newport Boulevard in Costa Mesa. The reason we wanted to build these was to have for sober living homes. And the reason we wanted sober living homes was very easy. 30 years ago was nothing but money. And I'm talking cash. After about a year of being in this business, I found out I couldn't stomach it. I didn't want to be around addicts, even though I have 2 that were living at home. And they do not belong in a residential area. They belong in a commercial area. This is a business. And I think most of the homeowners in Costa Mesa understand that. And Costa Mesa has failed miserably in not protecting the residential areas from these poisonous homes that are in our community. They do not belong in a residential area. They belong in a commercial area. They are a business. I'm happy that you have declined this. I don't think it has any business being on Wilson Street or any place in Costa Mesa except in an area where you can have these types of homes. It's something I think Costa Mesa should think about, because otherwise you're going to be just swamped with homes all over your city. I've been in that business. I don't want to be in that business. It's a dirty business. And your success rate is right around 40%. So,
Thank you, ma'am, for your comments.
who do I give this to? 20%. Okay.
Anyone else wish to speak on this item? Yes, ma'am.
So did you hear that hesitation when you asked them if they had any other houses? Well, actually, they have quite a few. And first of all, let's not forget, this is like a giant, like a Ponzi scheme or something. You come out here, you get yourself sober, and then you see, oh, there's so much money in this, and then you get your family involved. Hey, we heard this about Casa Capri, Windward Way. This is a reoccurring theme in Costa Mesa. Let's cut off the people coming from out of state to our city for this. So anyway, Ohio House was on the peninsula. They forgot to tell you this. They got thrown off and shut down on the peninsula for being a bad operator. Oh, well, we'll just move to Costa Mesa. So they have one over, they've got 2 houses over by the Boys and Girls Club. Why don't you ask those neighbors how they feel about the Ohio House? I just got a complaint today about that house. The guys racing down the driveway and all the stuff that goes on the porch. And this particular applicant tonight, I'm sorry, but it's a fraternity house. It's a giant fraternity house. Sometimes they're behaving. Most of the time they're not. They're all out in front. They use it like a football field. They don't smoke in the back. They're out in front all the time. By the way, there are vans. Those white vans. Also, so it's not just cars. There are vans parked there, and they van people to God knows where, drug testing, whatever they're doing. So they are providing services, so they misled you about that. And also, there's so many drugs on that corner. That is the most ridiculous place to have a rehab house of all time. I've never seen so much heroin. Everybody on the east side knows it. There's needles everywhere. Who knows if it's coming from their house or the other rehab people around, but there's a lot of heroin on that corner. Everybody knows it. Okay, so the other thing is, remember the situation on Joanne Street where there was a lot of nonsense with state licenses that was illegal. Remember, you guys were sitting up there. That was Ohio House. Okay, they're not good operators. There are good operators in this city. This is not one of them.
Thank you. Yes, sir.
Hi, guys. First meeting for the new year, so Happy New Year's to you all. This
Same
might
to you.
take a little bit longer because I'm going to give you a little bit of history, so I'd appreciate your time. First of all, how did this lot came to be? Well, it used to be a motel right across the street, which is currently the Vanguard housing tract. This was their spillway of parking. That used to be my yard where I kept my construction equipment. Matter of fact, I'm one of the contractors who built those 5 houses. They're single-family houses. They have literally 0 setbacks. That backyard you refer to, Ms. Navarro, it's about 12 feet. So hanging out on the patio? No, because they're right backing up to the condominiums on the property adjacent to them. The only unit within that complex that has anything that you might want to call a yard is unit number 5, which is the last one away from Wilson Street. Where do we start? Parking, they have none. The alley is a far away. They're not allowed to park in the alley, period. They don't use their garages. My property is walking distance, and there was no parking until I went there and I asked the house manager that if they ever park their vehicles on 23rd Street, I will have them towed. Because they would park there and leave them. According to their thing, they keep saying that they give them activities. I wish I could go to one of these things. Extracurricular activity opportunities including boxing, surfing, camping, hiking, deep-sea fishing. Who's paying for this? Paintballing and volunteer activities. I think they forgot perhaps jet skiing, water skiing, and snow skiing. But the kids are out in the alley constantly. I drive that alley perhaps 2 to 3 times a day back and forth from my office. On the weekends, it's a football field. They party. If they don't have enough people, the vans show up every once in a while, pick up a few people, and then they leave, and then they come back again. It's a rotation. This is not a sober living house. As some of the other speakers said, this is more a fraternity house. Let's go hang over. And what are they looking at? That's the front of the property on the alley. It's the backside of Circle K. Costa Mesa, notorious for you need crack, you need heroin, Circle K is the place to go. Why don't we find out how many service calls by Costa Mesa PD and Fire Department were actually at the corner? Not just at their residence, but at the corner. It's an accumulation of it both. Numerous times have I driven through the alley and there's somebody passed out on the grass. So, no, there is no accommodation to this thing. Okay. This is ridiculous. Thanks for the extra time.
Thank you, sir. Anyone else wish to speak to this item? Okay, seeing none, I will ask the applicant if they would like to come back up and rebut any comments they heard. Yes, sir.
Just want to say thank you for all the comments. Truly do appreciate it. And if there's one thing that we can stand up here and truly believe in, it's that we want to be a part of the solution for the city of Costa Mesa. Sure, there are bad operators, just like there are in any business, in any industry. We are not a part of that. We don't want to be a part of that. We actually want to be a part of the solution. So whatever the issue is, I think that there is some sort of common ground that we can come to where we can continue operating there and continue doing what we do and that we take tremendous pride in. So thank you for all the comments. We would love to improve some of our practices, some of our policies. But at the end of the day, I think that there's a stigma attached to this industry, and we're just taking the bullet for it tonight.
Thank you. Oh, go ahead, please.
Yeah, my name is Brendan. Couple things. There was a hesitation when they asked us if we had other homes in Costa Mesa. The hesitation, I should have cleared that up before I sat down. I knew it was going to get brought up. So the hesitation was simply because I actually had to think about it, because we were approached by the city for you guys had mentioned the Joanne property. The Joanne property was a different operator.
Yes, and sir, I just asked you to address the commission. That'd be great. I appreciate the answer.
Sure.
Keep going. No, I just don't want you to turn toward the audience.
The
There you go.
other operator of the Joanne property went out of business, and we took over their properties and moved them into Ohio houses. When we did so, we didn't realize that they had already had a meeting with a planning commission meeting set up. We were advised not to even go to it because it wasn't for our business. We decided to show up and let you know that we had just taken over operations of that facility and were willing to resubmit an application in our name because now we are operating that property. And when the city said no, instead of appealing it like where we're at today, we actually decided in good effort to build a relationship with the city to leave. And we left those properties, and we haven't operated there since then. And we also did that with another property just last month in San Bernardino, on San Bernardino Plate. We left. The reason we're here today is because we're not leaving Wilson. The fraternity house that's been talked about is what we like to call a community. And when you're talking about the city of Costa Mesa having character, I think that goes to what the community represents. And I can tell you, our community, you can walk out your front door and you can go knock on the door next door and you can have a relationship with your neighbor. And I don't know what the character of Costa Mesa is, but I do know that it was nice to see some of the awards and some of the pictures that were taken. And I noticed that when all of you guys got up here to take that picture, you had a smile it was a prideful smile. You were proud of what you do for a living. You were proud to be here tonight and represent this city. And I can tell that when you're looking at this application, you are going into it thinking, how can I protect what I'm so prideful of? And I ask you, before you make that decision, you get to know us a little bit more and understand what we're doing before you make a decision that you may regret down the line. So the neighbors are great. We have great neighbor relationships.
Ms. Parker, please. I mean, I'm sorry, sir. I'm gonna stop. So when you spoke, they didn't interrupt you. So I understand you're passionate about the issue. I understand that, but we're not going to have the audience talking over the applicant. Thank you very much. Go ahead, sir.
What I was saying with the neighbors, I mean, as far as rules and policies and procedures and how we operate, I mean, it's sharp. It's nail, bolt, sharp, tight. And it's a great operation. But with the neighbors, I mean, we have a great relationship with our neighbors. On holidays, they bring us cookies. We do the same for them. They write us letters. They drop us cards. The next door neighbor to one of our properties' son had a problem with heroin addiction, and they called us, and we put him through our program, and that guy's still sober today. So anything we can do in regards to communicating with our neighbors, some of these complaints about the football field, this is the first time I've ever heard that complaint. If there's a complaint on our program, I would love to be the guy that fields that phone call. And I'll give out my phone number. It's 949-554-8364. And if anyone in this room has complaints about our program, they can call me directly and I'll fix it immediately. Thank you.
Thank you, sir. Commissioners, are there any last questions for the applicant before I close the public hearing? Okay, seeing none, thank you, gentlemen.
Thank you all.
Thank you. I close the public hearing, and we'll bring the matter up to the commission for any comments and or motions. Commissioner Colbert. I close the public hearing. That would be receiving evidence, so probably not at this stage. Commissioners, any comments or motions? Okay, I have some comments preceding the motion. First of all, I want to acknowledge the important work that Ohio House has done for obviously a lot of residents, helping them become sober and stay sober. Courageous work, and I appreciate it. We do have some regulations in the city with respect to our sober living homes. And reviewing the evidence presented in the record from staff and listening to the testimony tonight, I'm particularly struck by some answers from the applicant relative to a denial of a CUP leaving their existing residents in that location. They seem to acknowledge that there are other opportunities, facilities they have in Costa Mesa where they could go if it was denied. I'm going to move that we adopt a resolution upholding the director's denial of the request for reasonable accommodation, denying conditional use permit PA-17-10, subject to the findings for denial in Exhibit A.
I'll second.
Okay, there's a motion on the floor and a second. Motion by the chair and seconded by Commissioner Woods. Any comments?
Mr. Chairman?
Commissioner Zick.
So I'll support your motion, and it's because I don't see another motion that furthers the possibility for the Ohio House to be successful in that location. A continuance of this item doesn't do that. When they have a letter that states that they essentially don't feel they need to comply with the Costa Mesa Municipal Code, that's problematic to me. That doesn't mean you don't have an opportunity, I would imagine, to reapply with the city. And instead of asking for 45 occupants, if that isn't really what your intention is, and that was just an upper limit you were seeking, put in what you're really intending to do. If you have house rules that you manage with, include those. I'm very impressed with both what Ryan and Brian contributed at the podium, but I don't see that sentiment in the correspondence. So if that's really who you are and what you're about, then I'd say keep working with the city and see if there's a way you can be successful there. But what's in front of us here doesn't support overturning the director's denial. Thank you, Mr. Chairman.
Okay. Any final? Yes, Commissioner Colbert.
I would like to ditto Commissioner Zink's comments and also state that I also will be supporting this motion in the fact that looking at the municipal code and that I just could not find any other reason, as Commissioner Zink stated, that what was communicated this evening did not come through with any application. It is also important. I think what you're doing is also important, and I also would like to applaud the work that you continuously do for this community and those who are impacted by drug or alcohol use.
Okay, thank you. Commissioner Woods? Oh, Vice Chair Harlan.
Okay. I don't get to be last this time. So I'll echo the sentiments of my fellow commissioners in that I believe the applicant is genuinely passionate about what they do, and I think that came across tonight. So I want to commend you for the work that you're doing, and despite what some people think it is an important service in our community, it does yield benefits. Clearly there are some impacts throughout our community, but you know, it is important work, and you seem to have had some success. So I want to commend you on that. For me, this is strictly a land use issue. I think that our city code, which has the 650-foot buffer, is a legitimate exercise of our city's police power. I don't see any reason presented tonight that would lead me to believe that that should be modified in any way or that there should be some accommodation for this particular applicant. I think there are other ample reasons provided in the staff report, specifically as it regards the single housekeeping unit. I find little evidence from the applicant's counsel that what is actually here is the functional equivalent of a family. There really is no evidence for that. So I will support the motion, and I will leave it to Commissioner Woods to conclude.
Commissioner Woods.
Yeah, I agree with all the fellow commissioner comments, and I wanted to wait till the end because I didn't want my own personal experience to bias how they thought about this application, but I just want to share that with you now. And I think where I'm really perplexed is that you mentioned you have 5 units and each one has an on-site house manager. As you know, parking is really bad on that street. My dry cleaners is right across the street, and I often park in front of the, on Wilson Street in front of those condos, your condos, because there's no parking. Great Mex takes a lot, I think it's called Great Mex. It takes a lot of the parking there, and there's a manicure place, and women will stay there for 45 minutes or an hour to get their nails done. So I'll park in front of your house a lot. At least on 4 or 5 different occasions, every time that I've parked there, I found myself face to face with a group of men smoking, vaping, and they don't just glance when I park there. They stop and stare. And I can't tell you how incredibly uncomfortable it is for a woman, especially in this day and age when we're seeing a spike in crimes against women and minorities, to be standing there sort of, at first I thought I had coffee on my shirt, and I looked down and I'm like, okay, there's no coffee on my shirt, whatever. Went, got my cleaning, nothing, didn't think anything of it. The second time, same thing, group of men standing on site, again with 5 house managers nearby. Same thing, just stops and stare. Not a casual glance and continue on with their conversation and their smoking and their vaping. I don't have any problems with the smoking or the vaping. But the same situation where they just stop, conversation stops, and they're just staring at me. And I just kind of have to wither into my car. I stopped going to that dry cleaners. Now my husband is the only one that goes. I stopped going to the Circle K. I stopped going to Great Mex particularly because of this residence. I feel incredibly uncomfortable every time I'm there, and every time I go, there's men congregating in the front. And I'm super sympathetic about sober living homes. In fact, socially, I know one gentleman that lives in one of our city's permitted sober living homes. He's incredible. He's engaging, he's doing a great job with his kids, and he's interesting, and I try to be really positive and supportive around him because I know that he's doing the best that he can. I don't feel that same energy when I go in front of your home. And so you mentioned some of your house rules, but I think you guys really need to go back and really talk to your residents because they're not adhering to those rules. I could personally tell you. And I wanted to hold off on that comment because I didn't want my personal experience to sway my fellow commissioners. But what you're saying and what I have observed on at least 4 or 5 different occasions, it doesn't match up. So I wish you luck. I wish you a lot of success. Good luck.
Okay, I will call for the question on the matter.
Mr. Chairman?
Yes.
Before you call the question, I just want to clarify that the motion was both to uphold the denial of the reasonable accommodation and also to deny the conditional use permit. Is that correct?
That is correct. Okay. Call for the question.
That motion carries 5-0.
Thank you. And that decision is final in 7 days unless appealed to the City Council. Thank you. Okay, we'll allow staff to shift around a little bit. Oh, wait. No, actually, we don't need to because Ms. Bowens-Colleen's got the planning hearing. Item number 2. Julie, please.
Public hearing item number 2, planning application 18-23 for variances from interior landscaping and setback requirements with a minor conditional use permit for compact parking to accommodate the expansion of a private parking lot into public right-of-way with an encroachment permit at 234 East 17th Street. This item was continued from the January 14, 2019 Planning Commission meeting. This is a call to report any ex parte communications.
Thank you. Commissioners, any ex parte communications on this matter to report? Okay, seeing none, Ms. Bowens-Colleen.
Sorry, I guess I don't have to announce my name again. You've got that.
Oh, because I just have so much fun saying it, actually.
So as you mentioned, or as Ms. Colgan mentioned, this request was originally scheduled for the Planning Commission meeting of January 14th, 2019. Prior to the meeting, staff received 12 emails from 11 people that resided in the vicinity of the project. 3 people also commented at the Planning Commission meeting of January 14th, 2019, and all of them expressed their concern with the proposed project because of the removal of the landscaping and the buffer that that landscaping provides between the commercial property and the residential developments. So on that basis, the applicant requested and the Planning Commission granted a continuance to tonight, February 11th, 2019, to allow the applicant time to consider public comments. Applicant has since revised the proposal to remove the block wall that was originally proposed along the Cabrillo Street frontage. Bottom line though, the real request was to expand the existing commercial parking lot by adding an additional 16 parking spaces. In order to accommodate these additional 16 parking spaces, the applicant needs to extend the parking lot into the public right-of-way. So the applications necessary to facilitate this request include variance from street setback landscape requirements along both Cabrillo Street and Westminster Avenue, a variance from the interior parking lot landscape requirements, and a minor conditional use permit to allow an additional compact parking space for a total of 11 compact spaces. An encroachment permit with final action before the City Council will also be necessary. This slide shows you the vicinity of the parking lot and also the zone of the property, which is P for parking lot. And then I have a few photos of the site. This is the north side of the parking lot adjacent to Cabrillo Street, and you can see some of the existing ficus trees at in the parking, in the setback landscaping. And then also looking toward the southwest corner of the parking lot, southeast corner of the parking lot, some of the landscaping that was redone at the time that Greenleaf Restaurant was established at this location. And then unfortunately a little bit of wear and tear. As you can see, some of the landscape area has been, I'm assuming, run over by delivery trucks, something like that, some of the paving of the landscaping. Here's the, paving of the parking lot. Here's the existing site plan as you see right now. Proposed site plan has the parking encroaching into the public right-of-way on the right-hand side, if you will, of the site plan. And here is the cross-section as originally proposed with the landscaping provided as vines on top of a new wall that would be behind a new public sidewalk constructed directly behind the curb. In these 4 weeks since the item was continued, the applicant did provide this alternate in response to the comments by the neighbors looking for additional landscaping to soften that buffer between the commercial and the residential properties. And so they did propose an alternative which removed the wall and actually puts in maybe some more shrubs or some grasses along with the trees to provide that softening they felt the neighbors were looking for. Here's another of the proposed landscaping with the wall. Some new trees to replace the parkway trees that would have to be removed. And then the valet parking would remain substantially the same. Basically, it will stay in the outside perimeter of the parking lot along Cabrillo Street. The municipal code does require specific findings be made in order to approve a variance, that there has to be special circumstances, that strict application to development standards would deprive the property of privileges enjoyed by others with the same zoning, that the deviation granted does not constitute a grant of special privileges, and that the deviation would not allow a use, density, or intensity which is not in accordance with the general plan designation. Unfortunately, no special circumstances applicable to the property that deprive it of privileges enjoyed by others with the same zoning, because the property does exceed minimum lot width and area requirements, and the property is flat and regular rectangular in shape. Without the approval of the variances, which would facilitate the addition of the 16 parking spaces, the 11 compact parking spaces that are proposed would no longer comply with code requirements. Approval as a consideration would provide additional on-site parking, which should lessen the impact of employees and customers parking on adjacent streets and properties. The proposed curb-adjacent sidewalk configuration would be consistent with other properties on Cabrillo Street, and the current parkway and setback landscaping is an attractive area for homeless and because of its separation by a block wall, or at least the block wall that had been existing out there from the parking area, that landscaping didn't really act as a function or function as a unified part of the parking area on the property. Another consideration, although a portion is within the setback area, 2,363 square feet of landscaped area will be provided throughout the parking lot to soften the paving, 363 square feet more than required by code for the required parking. And the street trees that will be removed to accommodate the construction will be replaced with new trees that have been approved by the Public Services Department. The trees will be placed adjacent to and will shade the new public sidewalk as required by the Parks and Recreation Commission. So staff recommends that the Planning Commission find the project categorically exempt from SEQA under SEQA Guidelines 15304 and adopt a resolution to either approve, subject to conditions of approval, approve with modifications subject to conditions of approval, or deny the project. And I'm available if you have any questions.
Thank you, Ms. Bowens-Clean. Commissioners, any questions of staff on this? Commissioner Zick.
Thank you, Mr. Chairman. Two questions. One is about the existing condition on Westminster, where I see red painted curbing. And on the side of the street furthest from the parking lot, there's a fire hydrant, so I'm assuming that's why that curb is painted red. But immediately adjacent to the parking lot, the curb is also painted red. I was curious why that was, if staff knew.
Commissioner Zick, are you referring to the photo that's on the page of, handwritten page 18 of the staff report?
I'm not sure. I can't tell from the orientation.
This is the curb that is on the north side of the alley, just as you come in off of Westminster into the parking lot. The little bit of the white that you see at the top of the photo is
Yes.
green leaf. Okay.
I think that is. And the reason I'm asking is it would seem that without that red curb, there'd be more street parking.
That red curb that's shown on that picture is actually adjacent to the public alley, and there would be inadequate room to park because they need a certain clearance for fire access, et cetera.
Okay, so I'm not referring to along the alley, although this may be an extension of that same red painted curb that is out on Westminster. If you don't know, that's okay. That was my question, though.
Yeah, Commissioner Zick, if you'll give us a few moments to take a look, and then we'll come back to the commission when we have a response.
Okay.
Thank you.
I have a second question. So this project was originally approved back on January 13th of 2011, and it had a set of conditions of approval that went along with that. My question is, do those conditions of approval, are they still in force?
They will still apply, and they would still be enforced.
And so specifically, condition number 6 of those conditions of approval, which states, if parking shortage or other parking-related problems arise, the applicant shall institute whatever operational measures are necessary to minimize or eliminate the problem, including, but not limited to, hours of operation, reduction in outdoor dining area, and/or valet parking. That condition still apply?
That's correct.
Thank you, Mr. Chairman.
Thank you. Commissioners, any questions of staff? Vice Chair Harlan's reaching for the button.
Thank you, Mr. Chair. So I'll just say Willa. I do enjoy saying your last name, but we'll just go for Willa right now. Are the ficus trees within the public right-of-way?
No, they are not. They're on private property.
Okay, so the property owner could conceivably remove them as they see fit.
There is a process in the code. They would have to get approval from staff, providing justification why mature trees are going to be removed, and there's a code requirement that they be replaced with something that's comparable in size under the direction of staff on a one-to-one basis.
Okay. And what about the other trees on the parkway?
The trees in the parkway are subject to review and approval by the Parks and Recreation Commission, which Mr. Ward did apply to the Parks and Recreation Commission, did get approval, and has proposed trees that are acceptable to public services as a replacement.
Okay, but they're only proposing to provide one line of trees, basically.
That's correct, because by the time the parking is relocated, there will not be a parkway anymore.
Right. Okay, thank you.
Okay. Commissioners, any more questions of staff? Okay, I will open the public hearing and ask the applicant to come forward. Good evening, sir.
Good evening. It's a pleasure to be here. I'm Brian Ward with Burnham Ward Properties.
Floor is yours. Do you have a presentation, or are you just there for questions?
Well, here to address any questions and specifically to talk about the alternative that we proposed, to see if there's any comment or questions on it.
So just since I sort of know, but maybe for the audience, education, the genesis of the alternative that you presented tonight.
Well, based upon the comments, when we decided to continue the project from the last meeting, it was apparent based on a couple of comments that actually the removal of the wall was attractive to some of the people because it opened up the view corridor and made the space appear and exist as a much more open space. So our intention, because the wall was undermined because of the overgrown ficus, it was crumbling and it was unsafe, and so we had to immediately remove that wall, but the intent was to rebuild it in its place after we dealt with the overgrown ficus, or relocate it under this proposal that we've submitted to staff.
Okay. Commissioners, do you have any questions of the applicant? Commissioner Woods.
Hi, tell me about your valet plan at Greenleaf. What hours do they operate, and how often are they there?
Greenleaf and I might want to clarify that we really do not have a parking problem on the site. The attempt to add more parking is not because it's badly needed. It's a smart thing to do because parking is always, a highly sought-after commodity anywhere along 17th Street. So we have situations where we have neighboring properties, and everybody competes for parking. So cannibalism by neighbors is kind of a common occurrence. So we have the neighbors parking on our property quite a bit. And so, again, to sort of just create more parking on commercial properties, that's why as stewards of commercial property along 17th Street, which we have multiple, we often attempt to do things like this whenever we can.
So then will there still be a valet station there?
Absolutely.
Okay, because they seem to have limited hours. There's been times I've gone to Greenleaf and I've used valet parking to park there, and then they say, you got to leave by, I think it was 6 o'clock. I said, well, we just got here. And they found us in the restaurant, dropped off our keys, and left. And I thought, well, if there's a parking issue here, why is valet going home so early? And why aren't they staying open until, the hours of operation for Greenleaf or some of the other businesses that are using the majority of those parking spaces?
That's a great question, and that's exactly right. We have a shared parking arrangement. So we have office tenants that predominantly occupy the building, and so they tend to leave by 5 o'clock, where we have more parking available in the lot. And so the valet isn't needed during those off-peak hours because we have more parking. So what we do is we have the valet on site to address those peak hours where we do have some conflicts with parking between the office tenants and the restaurant tenants. And it seems it has been working very, very well. We haven't had any complaints from anyone in the lot or in the building, the tenants in the building. And like I say, the more common occurrence is cannibalism from neighboring uses. into the lot, because when you do have parking, people tend to grab it and then walk across the street.
Yeah, okay. So I guess I was under the impression that this was a response to neighboring complaints about the parking situation.
No, but, again, we're trying to be proactive with this request, because we do have occasions, because there is public street parking available, and whether our properties, including our neighbors' commercial properties, we're also a part of the public. So we do have patrons that visit our centers that do occasionally, when there's no parking available, overflow at peak hours onto to the street parking. Ideally, what we like to do is try to keep that street parking available for the residents, because many of them have guests and have need for street parking. So we try to do what we can to take our people off the streets and put them in our projects. That's why we're here.
Okay, I have another question. Planning staff mentioned that 2,363 square feet were devoted to landscaped areas within the parking area. Why not flip that a little bit? Put parking in those landscaped areas and then leave and explore the alternative that doesn't involve encroaching onto city property?
Well, there really is, there's no way to expand the lot without encroaching somewhat onto that lot. And again, what we've attempted to do is plan our parking lot, the expansion, to where we maintain the same configuration with right-angle parking. I was just looking at the plan with my architect as we were listening to the last applicant, trying to figure out if there are ways we can even expand that setback further from the sidewalk to the parking lot. And we believe that there could be ways to expand it further by adding potentially a one-way during that back, or through that back row, and maybe do some angle parking where we could narrow the aisle width that we're required to maintain for right angle and increase that setback a little further. Again, our goal is to get the sidewalk realigned so it's straight and consistent with the neighboring properties in the entire neighborhood, and then to create as large of a setback as we can with street trees, brand new, fresh environment, and create some more parking where it doesn't exist. Just be responsible neighbors.
I guess I'm confused, but I'll redirect to planning staff about that. Okay, that's all the questions for now. Thanks.
Sure.
Commissioners, any other commissioners' questions? Vice Chair Harlan.
Thank you, Mr. Chair. Just one quick question. What species and size will be the replacement for the ficus?
The current application had Pittosporum, gracilior, fern pine.
Excuse me, sir, just a minute.
Yes.
Ms. Parker, please. Okay, thank you. I don't want to send you to your rooms without dessert, so, all right, thank you.
So the current application shows fern pines, Podocarpus gracilior at 36-inch box. There was also an alternate approved tree, Magnolia Samuel Summers, that Public Services and Parks and Rec Commission approved, and the client is also considering that tree as well.
Okay,
same size.
Did Parks and Rec Commission have input in that?
They did. They recommended those two trees.
Okay, thank you.
Okay. Any other questions? Okay, thank you, gentlemen. I will open this to public comment. Anyone wishing to speak on this item, please come to the podium. Good evening, ma'am.
Hello. My name is Sarah Leyland. I, along with my husband, am the owner of 240 Cabrillo Street, which is directly across from the proposed project. Let me start by saying that we absolutely love Serrano Plaza. We love living in an area that is so close to so many businesses. We highly value the walkability of our neighborhood. And while embracing change is part of our core values, we feel like this development is not positive for the neighborhood. Our house sits directly across the street from this parking lot, so we can see very clearly from out of our window. And I can tell you that the amount of foot traffic on a daily basis by people walking to yoga, walking with their strollers, and walking their dogs, it's not just residents of Cabrillo Street, it's residents all over Eastside Costa Mesa. It's one of the main thoroughfares to everything that Eastside and 17th Street has to offer. The plan set forth to move the currently buffered sidewalk to the busy street. The required setbacks between retail and residential are set forth for a reason. And once it's gone, and we can never get those old growth eucalyptus trees back. So I'd just like to say, please keep Costa Mesa standard for aesthetics. Keep the city, the wonderful city we love so much, as beautiful as we know it can be. The walkability of our neighborhood is a crucial part of what makes Eastside Costa Mesa such a gem. And with that in mind, I urge the Planning Commission to deny the variance.
Thank you very much for your comments. Yes, sir.
My name is Andrew Leyland. My wife Sarah and I live at 240 Cabrillo, just across the street from the proposed project. I ask that you protect the residents of Eastside Costa Mesa and our public right-of-way by declining this encroachment. We love our neighborhood and the local businesses on 17th Street and at Serrano Plaza. The walkability in Eastside is one of the reasons that it's so special. Every day we see residents walking with strollers and dogs, taking a morning jog, walking to get lunch or a cup of coffee. The walkability is not by accident and can't be taken for granted. The city's been investing on Broadway and 19th. We've put in new monument stones. The neighborhood is embracing its unique access to commercial amenities, but still maintaining a neighborhood that is safe for families. Let's protect these investments and continue to create a safe and beautiful East Side. The landscape buffers and setbacks create a safe walking path that promote an active lifestyle, reduce traffic, and create a vibrancy in the neighborhood. The proposed project requests that the 15-foot landscape setback requirement and the 6-foot landscape buffer be reduced to an 8-inch planter. These codes exist for a reason. The setback and landscape buffer requirements are critical for creating harmony between the commercial and residential zones. As we develop the 17th Street corridor, let's preserve what makes this neighborhood special and protect the residential environment that feeds the commercial development. Let's protect the families and the kids that live there. I urge the Commission to deny the variance request and protect the beauty and harmony of Eastside for all residents. Once we lose it, if we lose it, it will never come back.
Thank you, sir. Anyone else who wishes to speak on this item, please come forward. Good evening.
Good evening. My name is Trifon Metodiev, and I'm a resident at 222 Cabrillo Street. And I'd like to point out that the applicant was very sincere and honest in his responses, and that was really nice to hear. So I appreciate that. But with that being said, I agree with the other speakers that reducing that landscape requirement to almost nothing, which I think in the revision is a 2-foot planter, is eliminating all the landscape buffer that we have between the commercial and the residential district. And we do cherish that aesthetic and that character that we have, and we walk down that sidewalk all the time. And even though the wall would be gone in their proposal or alternate, you would have a row of cars that park there. And I think it was nice to hear that the applicant was honest about that they don't really need the parking. That lot is not at maximum capacity, almost never. Maybe in the peak hours, but that's about it on Friday or Saturday evening. There's other commercial properties adjacent to it that, yeah, they spill over, but there's another adjacent closer to Orange, which is most of the time empty as well. So they could arrange for shared parking agreements with other commercial properties adjacent to that. I don't think they should take away from our residential landscape requirements that really provide a buffer that's there for a reason. I appreciate it. Thank you.
Thank you, sir. Yes, ma'am.
It's really fun to come to these meetings because you always catch something. Okay, so first of all, if they take away the wall, when people are parking at night, sorry you guys, but those headlights are going to go right into your houses. So for that reason alone, you should leave the wall. Plus the fact that is our property. That property belongs to these residents that just got up and spoke, and you're just going to give it away to someone that doesn't live in Costa Mesa, by the way, the owner of that area. He lives in Newport Beach. And I just want to say that as far as cannibalism, why do the people across the street at Shirley's Bagel have a guy sitting in the parking lot with a sign that says, no Greenleaf parking? You want to talk about cannibalism, that Greenleaf restaurant, which I really like, it's a great restaurant, by the way, but it was underparked, remember? Go back and look at the Planning Commission. Oh, it won't matter, it'll work out. Every time you pass something underparked in the city of Costa Mesa, it causes problems later on. So before you pass this, I would like you to all go over there some evening or afternoon or morning. Go Saturday morning. There's a guy sitting over at Shirley's Bagel with a sign, no parking for this complex. And if you take away that wall, they're going to get all those headlights. And if you take away I don't even think you should be removing the trees. I think they're beautiful. I think it's funny you won't help homeowners, but you'll help a developer get rid of trees.
Thank you. Yes, ma'am. Good evening.
Hello. I'm Valerie. I'm a 30-year resident of Cabrillo Street. I live right across the street from the area in question right now. And I would agree with my neighbors that putting in an extra row of concrete, parking places and then detracting from the green space is not a good choice. We really enjoy that. And I also kind of like the wall being down, so I really appreciate that they kind of listen to us there. It opens things up, and less people tend to hide behind the walls and whatnot. So it's just all open. We don't have any issues with that. But taking away those gorgeous trees, yeah, I have an issue with that. It's like pave paradise and put up a parking lot, just like that Joni Mitchell song. So anyway, please consider our remarks, and I think that would be good if you buzzed by and checked it out yourself too. That's a good suggestion if you have time. Thank you.
Thank you. Anyone else wish to speak on this item? Seeing none, I'll ask the applicant if you would like to come back up with any other additional comments or stay right where you are. Yes, sir.
I just want to say I appreciate very much the comments. We really do try to listen. We own a lot of property in the city of Costa Mesa, and we really do try to be responsible stewards of our assets, our properties. I would like to open up for discussion the possibility of widening. I think in removing the wall, we actually create the setback at just over 3 feet. I'm open to widening that even further so we can create more landscaping. As to putting back the wall, happy to do it, but listening to the residents, if they really like a more open feel, perhaps we could plant a hedge in that area that we have to work with at the base of the trees so we can get that hedge high enough to cover the lights of the cars, if that's what they would like. So I'm completely open to landscape material, to a different type of fence, whatever works best for the residents, I'm completely open to it. Okay. So, and as to the fact that it's our property, their property, I do want to note that the property that we're talking about expanding into is our fee land. We do own that land. The city does have an easement on it, and that's why we're here today. But it's not the city's property, it's ours. So I just want to make that comment not because it entitles anyone to anything more, because there is a clear restriction, but it is a way for us to try to use property that we do own, but yet execute on the intent to create the parkway, or whatever parkway we can with what we have. That's it.
So while I have you there and the public hearing is still open, let me ask, either staff can answer this or maybe both of you can answer this. Have you had issues relative to transients camping overnight interior to that wall, or maybe in the landscaping on the other side of the wall, because they tend to be great ways to hide things? Do you have any kind of reporting on calls for service to?
I can tell you
Yes,
as the property owner, absolutely yes. When the wall existed, based upon the size of the trees and the foliage that existed, we did have homeless camping around the trees. The wall was also built in an irregular fashion to accommodate the large trees. So we had some nooks and crannies, again, that we inherited when we bought the property. So we would often have to go back there and clean those areas out. And there was, we found all kinds of paraphernalia back there, which, removing the wall has really helped a great deal with, because there isn't any place for people to hide. The other thing is, because we had a solid wall, we couldn't see on that side of our property. The residents could see that side, but we couldn't. So it made it very difficult for us to police and maintain that area. So again, we kind of like it the way it is turning out. We've embraced some of the comments and we agree with them. We do think it's prudent to have some kind of a buffer so we don't have situations like, lights going into residences' houses. We don't think that's a good thing. So I think there's some things that we can do to, to mitigate those kinds of impacts, at the same time create a great setback for the residents as well. So.
Okay, thank you.
Sure.
Vice Chair Harlan.
Before you close the public period.
Sir.
Sir, Mr. Burnham, one quick question.
He has another question for you.
It's actually it's more for your designer.
That's right. You get your steps in today.
Yeah.
I will say I'm in the ward, not Mr. Burnham. I'm the ward in Burnham Ward.
Okay, my apologies.
My partner's not here tonight.
Okay. I'm not going to let you go, though. So I appreciate your willingness to try and come to some accommodation with this design. My question is, excuse me, is it preferable to do a additional setback on the street side or back towards the parking lot?
I would say back towards the parking lot. Again, we're open, but our property is the only property where you have the sidewalk. And we do have a church down the way and other non-residential uses that have the same straight sidewalk configuration. So we have the unusual situation where we have parkscape, sidewalk, and then landscape setback. What we're trying to do is align the sidewalk so it's consistent with the entire neighborhood, and then add buffer beyond the sidewalk. Does that answer your question?
It does. I mean, I'm very familiar with this area, and yeah. You're correct. This is an anomaly in this neighborhood. What I've heard, and I want to hope we can address, is this notion of walkability and what would be the better design option to enhance walkability, or at least continue it. I have my own issues on this, and I'll talk about that in a moment. But since you're willing to provide that, I want to just get your input on the preference.
What we would like to do is relocate the sidewalk, which again is no inexpensive feat for us to do. Right. But the ficus trees they've just run rampant, and they are big, beautiful trees. We hate taking any trees out because mature trees are really hard to replace. But these ficuses are wreaking havoc, not just on the fence that we've had to take down, the wall, but also on the sidewalk and the setbacks. To be able to properly redo those planter areas, we'd have to remove a lot of roots to do that, and that might undermine the trees themselves if we start tearing up all the surface roots that exist. So removing those trees and coming in with a new set of street trees that would promenade down this new sidewalk, we think would be the best approach. And that's what we proposed.
All right.
Okay. Thank you, sir.
Mr. Chairman?
Commissioner Zick, I'm sorry.
I have a question for staff, but I wanted to ask it before you close the public hearing. And the question relates to the responsibility for maintenance and landscaping of the existing parkway space that's between the sidewalk and the curb. Is that the city responsibility?
No, it's not. It's the property owner adjacent.
And is there a requirement for landscaping in that area?
Yes, there is.
Okay. And the area then that is further south than on the other side of the sidewalk, that also would be the property owner's responsibility to maintain and landscape that area?
Are you referring to that finger that I showed next to the alley or some other location?
No, I'm looking along Cabrillo.
Okay.
So there's the 4-foot parkway, 6-foot parkway, 4-foot sidewalk, and then there's some additional landscape area. So I'm just asking about the responsibility for maintaining that landscaping.
Mr. Chairman, Commissioners, the area that you're referring to, which is the landscape parkway between the back of curb and the sidewalk, is the responsibility of the property owner to maintain. That is per the municipal code. So it will be the responsibility of each adjacent property owner to maintain that parkway. I also wanted to add, there was a question before about red curb along Westminster, and I was able to look at Google Maps and took a look at some of the locations that are painted red and some of the areas that are adjacent to fire hydrants, as you had mentioned. And for those, it makes sense. It looks like additional red striping or red curbing was added at or near intersections for what because I don't have the history of this, assume that is for safety reasons to allow either sight distance or turning movements. For the areas north of the alley, there's additional red curbing that at this time I am unable to answer the question. I have to look into that and get back to you.
Thank you. Yeah, that was the area I was wondering about. Okay, thank you, Mr. Chairman.
Thank you. Commissioner Woods.
I have a question. And look, I understand your struggles with ficus tree. We used to have one on our property. It lifted our garage, our driveway. It was a pain. It's still trying to grow back, even though we've removed it about 6 years ago. But I'm curious, one of the things that's really important to our community, another thing that was raised with Parks and Recs Commission, particularly Commissioner Reynolds, who's now one of our council members, is walkability. And I think I'm struggling with that here. I see in your alternate plan that you would put a wall, right? And there would be vines. Can you explain your alternate plan a little bit more carefully and what we would expect to see there?
Yeah, that's not the alternate plan. That was the original proposal.
Okay.
And we've offered the alternate, as an option away from that.
Okay.
So walkability, there isn't any disruption of walkability in our plan. There admittedly is a reduction in landscape setback area, and that's what we're talking about, trying to figure out ways to keep that as wide as possible. Mm-hmm. There will still be a sidewalk. There will still be walkability. In fact, it'll be a brand new sidewalk, and there'll be brand new street trees along that sidewalk, as well as underplanting. How tall that underplanting is, whether there is some sort of a hedge put back that shields light, those are things that we're talking about here. There's no issue with walkability.
Okay, I guess when I think of walkability, canopy shading is really important, particularly anybody with mobility issues, because it takes you a little long to get from place to place, right? And you really get some sort of relief from that shading. It also provides a visual buffer between commercial uses and residential uses, and it also buffers against noise and headlights. We use it in natural systems all the time. We use trees. We don't, you can't put up walls in an ecological reserve, so we use trees, we use shading, we use a lot of bushes to provide not only sort of a visual buffer between our urban areas and our natural areas, but they serve the aesthetics. They serve the aesthetics of the region. They provide a noise buffer and a light buffer between those two uses. And so can you explain to me how your alternate plan would provide the aesthetic buffer, the noise buffer, light buffer, that overall increases the walkability of our neighborhoods?
Yes, the landscape setback that is proposed in the alternate plan, which again, we would like to try to figure out with staff a way to widen that even further, is in excess of 3 feet, and within that 3-foot setback would be a row of street trees we would put in as mature as we can. And because we're going to be doing this concurrent with the improvements, we would try to, drop in as large a boxes as we can in there to have mature trees with canopies over the sidewalk. And then what we would do is put back a mature hedge so we shield as much of that parking lot as possible in its greenscape. So we try to keep it as open as possible for the residents, so there's not just a wall put back. But if they want a wall put back, or you do, we can certainly talk about doing that as well.
So it sounds like there's still a lot of variables that could be worked out.
Well, I think that what we proposed is something that we're prepared to execute on immediately. That's admittedly probably better in the eyes of the residents than what we originally proposed. So I think we've made an improvement there. What I'd like to do is I'd like to sit down with staff and see if there are ways that we could widen that even further. But there's a point at which it doesn't make sense. If we can't create additional parking spaces, we're happy to just put it back the way it was.
Got it. So
we'll put the fence back, and we'll just move on.
If you're getting so much bleed over from adjacent neighbors, and I know you do, I see it all the time. I can tell you exactly where they're going. Why not address it with code enforcement? Why not talk to your adjacent neighbors and say, hey, we're having a tremendous parking problem here. We are having to invest a whole lot of money to try to increase the number of stalls in our space. Why not require their neighbors to require your neighbors to park their business appropriately?
That, while well-intended, is very difficult to police and monitor. It just happens. And as neighbors, we all try to work together, and what we're doing is we're trying to create the best environment we can for Costa Mesa residents to enjoy the amenities that you've heard some of the people talk about tonight. Restaurants, Pilates studios, places that they can go and enjoy, places to work, offices. We have some people that work at our building that ride their bikes to work, kind of a thing. So those are the things that we try to create, and we just try to be as responsible as we can. And adding parking spaces is a good thing when we can do it in a responsible way. And if you view our proposal as adding parking spaces in a responsible way, I encourage you to vote on it. If you don't, that's okay. We'll put the fence back and move on.
Okay, thank you.
Okay.
Okay. Not seeing any other commissioners with comments or questions. Thank you very much, gentlemen. I will close the public hearing and bring the item back up to the dais and see if there's any motion or commissioner comments. Vice Chair Harlan is reaching for the button.
I'm going much sooner than I like. So I appreciate the applicant's willingness to try and come to some design resolution here, and I think there is something that will meet the needs of the residents as well as the property owner here. I'm particularly appreciative of the fact that you point out that ownership of the property is in fee for the property owner. The public does not have a right to the public right-of-way as an easement, and that's an important legal distinction. What I've heard from the community, and I jotted down a few of the issues, it seems like a lot of this has to do with aesthetics, less to do with parking, more with walkability, which is not easily defined. There are certain elements that support walkability, namely feeling a sense of protection, having some continuity on the sidewalk, having a sense of enclosure provided by shade trees. But what I've noticed in this area, and I've been here several times, and I live on the east side, is that In this part of the east side, we do have continuous sidewalks, which is great. Where I live, we don't necessarily have that. But on this particular stretch, we don't really have any kind of continuity of street trees. I mean, I'm looking at the aerial of the site. This is the only portion of Cabrillo where there are mature trees. The rest of the homes don't have any trees. So the fact that they want to replace the mature trees with other mature trees to me is a positive and does enhance walkability and provide some sort of buffer. Even a larger setback, I think, also goes towards this issue of walkability. I'm kind of open to how we proceed on this. I mean, my inclination is that there is a design solution that can be worked out. I don't know if we need to continue the item. I mean, that's up to the commission.
Do you wish to make a motion, Vice Chair? Or?
I'd prefer to hear some
So
commissioner comments before we come to...
Commissioners, any other comments? Commissioner Zick, looks like you're ready to go.
I'm ready to make a motion.
Okay. So we'll let you have at your motion then.
And I'm certainly open to somebody making a substitute motion for continuance, but my motion is going to be to deny planning application 18-23 based on the findings as described in Exhibit A, staff report, page 14, where this project does not comply with the municipal code. There are no special circumstances that would support the variance for the street setback landscaping on Cabrillo, the variance for the street setback landscaping on Westminster, the variance for the interior landscaping, the variance for the minor CUP for the compact parking, nor an encroachment permit, which would also require the City Council approval. I don't see support for any of that. I am concerned about parking. It's obvious a lot of people are concerned about parking, which is why when there are applications that come forward that are underparked, there's a lot of consternation about that issue. And when this project came forward in 2011, there was a lot of concern about parking shortage. And that's why there's a condition of approval that says, basically, if there's any shortage of parking or other parking-related problems that arise, the applicant shall institute whatever operational measures are necessary. It doesn't say anything about including the taking of city land to expand the parking lot. And the applicant has even said as much tonight that there really isn't a parking shortage problem that they're trying to solve. They just see an opportunity to increase the parking, and maybe that's a good thing for other people along 17th, and maybe it is. But I don't think it's worth taking city land and portioning it for parking. So my motion is to deny. Thank you.
Okay, is there a second?
I'm going to second that.
Okay, Commissioner Colbert seconds the motion by Commissioner Zick. I will actually offer a substitute motion. I'll explain my reasonings in a minute. But I would actually move that we find that the project is categorically exempt from the provisions of CEQA Section 15304, minor alterations to land, and approve subject to conditions of approval, approve with modifications subject to conditions of approval, or deny. Well, I'm kind of confused here. So approve planning application 18-23. And if there's a second on the substitute motion, I'll explain my reasonings.
I'll second.
Okay. So in pure form, in a vacuum, if an applicant came to me with a request for a variance from setbacks, minor conditional use permit, for more to add compact parking, and the reason he's asking for this is because he wants more parking for a he just wants more parking. My inclination would be no, to say no, but here's why this one I want to support it. One is it creates some continuity on the street with respect to sidewalk alignment, therefore walkability. Two, I think it will actually create a better landscape environment. And while I'm not conditioning it in the motion, I would encourage the applicant and staff and neighbors to get together and really develop a landscape plan that everybody can get behind, with particular focus on making sure headlights aren't shining into households. But the benefit to me of this particular application is you get better landscaping, you get walkability, better walkability. You also get more on-site parking, which is like a bonus. He may not have a parking problem now, but I'll take more on-site parking anytime I can get it for a minor variance on a piece of landscaping that is as close to being dysfunctional from structurally damaging the wall and just not being well kept. I think the stars line up for me on this because we get more on-site parking, get better landscaping, you get better walkability and alignment of the sidewalk with the rest of the neighborhood. So it's while it is a variance, and I understand people's qualms with variances, I think this one is a variance that actually produces a better result than the existing condition. Any other comments on the substitute motion?
Yeah, Mr. Chairman.
Commissioner Zick, and then Vice Chair Harlan.
Well, so I won't be supporting the motion. I think a lot of what you said makes sense. There's a lot of good ideas here. Unfortunately, I don't think good ideas are the standard for approving of variances. Just because it's a good idea doesn't, according to our code, establish grounds for approving a variance. Regarding the walkability question, the alignment of the sidewalk, so there's a slight jog in the sidewalk just to the west of the parking lot. It's not a problem to navigate the slight jog in that sidewalk. So from a walkability standpoint, I don't see this as being an improvement. Having the sidewalk immediately adjacent to the street, I think from a safety standpoint is more problematic, and I think more than offsets any benefit somebody might think exists for having the sidewalk be continuously straight. So anyway, I won't be supporting the motion. Thank you.
Okay, thank you for your comments, Vice Chair Harlan.
Okay. Well, I do want to point out, and I respect your position on this, Commissioner Zick. I wholeheartedly support the reasoning offered by the chair on this, and I don't have too much to add to that reasoning. I do want to point out two things again. One, this is not city land, so let's be very clear about that. Secondly, Cabrillo Street, in most instances, is a sidewalk adjacent to the street. That's the existing condition with walkability. So if there's a way to enhance that and improve that at this location, I'm all for it. And I would concur that getting on-site parking by an applicant in advance of having problems, and everybody clamors for more parking. This is a call that we hear all the time, particularly on the east side. I think it's a net positive in this case.
Okay, so I will call for the question on the substitute motion.
That motion failed 3-2 with Commissioner Colbert, Commissioner Navarro-Woods, and Commissioner Zick voting no.
Okay, and that brings us back to the original motion, which is to deny the application. So I'll call for the question on that.
That motion carried 3-2 with Vice Chair Harlan and Chair D'Ercole voting no.
Okay, and that decision is final unless approved to the City Council or unless appealed to the City Council within 7 days. Thank you. I would like to take a maybe 5 to 10 minute break, please. Okay, we're back. We can have everybody back in their spots. And I think we're waiting just for council. But we don't need him. Julie, public hearing number 3, please. There he is.
Public hearing item number 3, planning application 18-29 and ZA-18-41 for conditional use permit for a 3,000 square foot event space and a minor conditional use permits for an outdoor activity space, a coffee shop, and a deviation from parking standards based on unique operating characteristics for a multi-tenant office complex at 150 Paularino Avenue. This is a call to report any ex parte communications.
Thank you, Julie. Commissioners, any ex parte communications to report? Okay, seeing none, Mr. Inlows.
Good evening, Chair and fellow planning commissioners. I apologize for the gravelly throat. I'm a little bit under the weather, but my name is Dan Inlows. I'm the Economic Development Administrator, and I will be presenting on this item. As mentioned, this is a conditional use permit and minor conditional use permits for the proposed project at 150 Paularino. The existing site is located at the airport industrial area on the northeast corner of the city. The site is nestled between SR 55, State Route 55 to the west, Paularino to the south, and Pullman Avenue to the north and east side, right there. The project is an irregular shaped lot and is across the street from traditional industrial spaces, warehouse spaces, and office uses. And its unique location is identified as having a quality of the general plan identifying it as an industrial zone, but the zoning code identifying it as a commercial limited, within the commercial limited district. This is because it allows for a transitional space between the industrial areas within the import industrial area and the residential that's immediately on the other side of the State Route 55. The project site currently has 4 office buildings. Those office buildings form a triangle shape with a courtyard in the center, and then the surface parking is around its perimeter. 2 rows, one immediately adjacent to the buildings, and then one facing out towards the various streets that run along the property. It's important to note that the landscaping setback of 20 feet is maintained around the entire property because it abuts public streets on all sides. The buildings on the property are lettered A through D. A through C are single-story buildings with approximately 12,000 square feet, and building D is a 2-story building with approximately 35,000 square feet. The interior courtyard space that currently exists today is a passive landscaping with trees and lawn and turf areas with minimal sidewalk space that allows for efficient access between the buildings. The project that we're going to be describing, or that's being proposed today by the applicant, is including an outdoor activity space, programmatizing that courtyard space to make it amenitized for future tenants, including an event center space with inside Building B, a coffee shop in Building B to go along with the proposed tenant, which is field work, and because of these different uses and the collection of uses, a deviation from parking. This is a aerial of the proposed modifications to the landscaping. Excuse me. The courtyard space is being programmatized. It's transitioning this space from a passive landscaping space into an activated space, which would change the character of the space by amenitizing it to bring tenants out from their indoor office spaces and leveraging the temperate climate within California to better understand the impacts. Included the evaluation of this space within the parking study completed for this project was done by IBI parking consultants. They provided the study that evaluated the potential impacts of the courtyard to the surrounding uses and then those uses on the site as well. To dive a little bit more deeply into the courtyard itself, there's some specified uses that are part of the plan. The first are these nodes. These nodes provide permanent benching and seating throughout the space. The largest, obviously, a more large space for congregation, and the smaller ones, more intimate meeting spaces. The next type of use are these patio spaces. They are meant to co-locate next to roll-up doors so that first floor tenants can have immediate access to an exclusive space outdoor that's all their own, as well as being integrated to the overall courtyard itself. And then lastly, some small amenities, a bocce ball court and a ping pong table permanently established in the space, again to amenitize it and provide attractive amenities for creative office spaces and tenants. And the rest of it being continued use that already exists on site, namely hardscape to allow for pedestrian circulation through the site, as well as landscaped area to provide a verdant atmosphere. These are some renderings that are in the staff report as well, identifying the new look of the site, of the courtyard space. As you can see on the top, this is the larger node that was identified in the center of the courtyard. The bottom left is a small, more intimate meeting area, and then the bocce ball court to the bottom right. The rest of the entitlements relate to a specific building. This is Building B. Building B is the proposed new location for a co-working space, Fieldwork. They currently reside at 270 Baker Street. They're proposing to relocate to this existing space to capitalize on additional square footage, have an additional 3,000 square foot event space, and they want to continue and maintain some of the existing uses that have already been successful on their site, namely an existing coffee shop that they would like to bring over. This is the floor plan of Building B. The center is predominantly co-working spaces that will be rented out to small businesses and entrepreneurs. Then there is the event space to the far right. This is the 3,000 square feet that will be used for pitch launches and other events for the tenants of the co-working space, but they'd also like to leave this the availability open to rent this out to off-site professionals or off-site venues to come in here and use this event space as well. The other site is on the opposite side of the building. This is the coffee shop. This coffee shop is predominantly for the patrons that are within the office space, but will also generate some additional traffic per our parking study. They found this is the one use on site that may generate additional demand that wouldn't already be on the site. They found that the office uses around the courtyard wouldn't kind of have a multiplier effect because of the courtyard space, but the coffee shop would potentially generate more demand, and that was included in the evaluation that they conducted for the site. Both the owner and the fieldwork identify these as critical uses for a successful creative office space, and they're uses that we've also seen in other office upgrades that we've seen happen in the city. This is a rendering of the coffee shop that's at the corner. You'll see how it relates to a pedestrian inlet that feeds into the site. There's also a small node there of tables and chairs, a patio space for the coffee shop. So anticipating this coffee shop having a little bit more demand makes sense for our parking study and helps us assess the true demand on site. All these uses are in conformance with the general plan and vision for this type of space, especially commercial limited space. So the big question turns to is parking. Vehicular access, there's 3 ingresses and egresses onto the property, 2 on Pullman, 1 on Paularino. There's 237 parking spaces on site. As alluded previously, because of the existing non-conforming status on site and the base code requirement of around 330 parking spaces, a parking study was completed. The parking study was completed by IBI and provided a comprehensive review of the site. Some additional takeaways from that project included that outdoor activity finding that we talked about with office space not met, increasing demand. But another takeaway that we have gathered from this parking study is in regard to event spaces that have historically been parked at 16 spaces per 1,000 square feet based on a parking study completed in 2001. This parking study evaluated event spaces within the city and identified 12.33 parking spaces per 1,000 square feet as a more accurate read for the demand of parking for an event space. The staff feels this is more accurate and would be interested in continuing to use this ratio if Planning Commission is so pleased. As part of the parking study, 3 scenarios were evaluated. They're listed here, A, B, and C. Scenario A was an understanding the potential parking demand for outdoor activity space being activated on the site as well as a coffee shop. Scenario B included those additional uses plus an off-hours event center. This would allow for the event center not to operate it would have to operate outside the hours of the office use, so typically after 6 p.m., and would require that it couldn't, leverage any space outside of the indoor area, specifically retaining that event space to only be inside that 3,000 square feet. And then the last one, scenario C, is everything I just said, with the exception that the event center would be allowed to operate during office hours. So these are the 3 scenarios that were evaluated. As you can see on the chart, the parking demands were calculated by IBI, and the deficiencies concluded. Scenario A and B were found to be identical because if you have offset hours for the event center, there is no potential additional impact to that event center since that event center is going to be operating off peak demand. And scenario C obviously came back with the highest level of deficiency for parking on the site. At this point, staff coordinated with the applicant and they decided to proceed with scenario B, or proposed scenario B as the direction they would like to proceed. Now, this brings up the next question. As staff typically looks at deficiency as something that needs to be resolved, the next solution must be how the parking on site will be managed. This includes solutions that require some sort of discretionary review. Typically, these are valet parking solutions, rideshare solutions, or off-site parking solutions. As we brought forth these potential solutions forward to see if they wanted to be added to the project, the applicant provided information that showed that the current site, because of the site's being 40 years old and they wanted to conduct substantial upgrades to the site, some of those permits already in place for things that didn't require discretionary approval. The site currently sits at 41.7% vacancy. With a 41.7% vacancy, there is no immediate parking demand on the site. While code would suggest there is, once the vacancies decrease, there is no demand on site currently. So adding a conditional approval or seeking an additional entitlement this time would place a burden on the project that staff didn't feel was rightly timed. And so as part of this, the collaborative solution was a parking management plan. What this parking management plan does is it identifies and solidifies the fact that there is a recognized parking deficit on this site when it's at full occupancy, and establishes in this document 4 triggers which would result in the applicant needing to implement one or more of the following solutions. These solutions are identified specifically in the parking management plan. This includes off-site parking, valet parking, mechanical lifts, or strategic lease-ups. All of these would be solutions that would require them to come back to Planning Commission and seek additional entitlements, and the parking management plan would require that they seek those remedies if any of the 4 are triggered to the satisfaction of the Planning Division and Planning Commission if necessary for this provided solution. This is the recommendation at this time. Staff recommends that the Planning Commission adopt a resolution to find that the project is category exempt from the provisions of California Environmental Quality Act pursuant to CEQA Guidelines Section 15301, existing facilities, and approve the planning application 1829 and ZA 1841 subject to conditions of approval. At this time, I have concluded my presentation. I am available for any questions you might have, and our parking consultant, IBI Group, is also here to answer any questions that dive a little bit deeper into the parking analysis, as well as the applicant is here to present and answer any questions you might have. Thank you.
Thank you, Mr. Inlos, for your report. Commissioners, any questions of staff? Commissioner Zick?
A real quick one. I noticed condition number 9 says no food trucks allowed. Can you explain that condition to me?
Yes, Chair and Commissioner Zick. The justification for this condition of approval was based on the parking study's findings that retail food use like the coffee shop, potentially would generate additional demand. The concern was that additional food trucks that would come on site potentially would have their own following and therefore generate additional demand onto the site. And therefore, to make sure that we're comparing apples to apples in the future parking analysis, we condition no food trucks at this time.
Thank you for the answer.
I have a quick question about the parking management.
Commissioner Woods.
Oops, sorry.
That's all right.
Okay. You listed the 4 mitigation actions, right? Why not, I would be more interested in seeing mitigation actions listed where they could resolve the issue on site. So for example, the second one was the property owner may implement a valet parking operation. Are these listed in sort of order of preference, or can they just select among these 4 mitigation actions?
Great question, Commissioner Woods. Chair and Commissioner Woods, the response to that is there is no priority established amongst the 4. It would be a collaboration with the Planning Department division to ensure that whatever solutions, whether it's individually or a combination of solutions, would be satisfactory to diminish or reduce the parking issue that was happening on site.
Okay.
So if direction is, if you're interested in providing direction that you're most interested in finding solutions that are on site first, we'd be more than happy to take that into consideration.
Okay, perfect, thanks.
Okay. Commissioner Colbert.
Thank you, Mr. Chairman. Just one question to staff regarding, within the staff report, it did state that this property was similar to the Met, the Hive, the Bank of America building, and the Town Center. And I did notice that within, I know specifically within the Met, they do allow food trucks. Can you tell me how this particular property would differ or deviate from the parking analysis, or?
I apologize, Commissioner Colbert. And Chair, I didn't necessarily heard enough of that question to make sure I answer it completely. Are you inquiring about, wondering specifically about the food trucks and how they relate to the other sites documented in the staff report?
And how they relate to?
And how they relate to the other projects listed in the staff report?
Yes, exactly.
Okay, I just want to make sure. Thank you. Food trucks on this site, again, were identified specifically because of the parking study and the parking management plan that was implemented on this site, which makes it, in that essence, different than the other sites that were identified as creative office spaces that have recently gone through refurbishment, because those sites met their parking demand.
Mr. Inlos, just a quick question, so I want to make sure I understand that staff has basically determined that the outdoor spaces, apart from the outdoor space associated with the proposed coffee shop, do not by themselves generate parking demand.
Correct. That's a short answer. But if in a longer-winded answer, I guess, would be specifically for office spaces. So if you have courtyard spaces that have been activated with meeting areas or amenities such as described in this project, if you have office spaces surrounding it, then you don't tend to see an increase in parking demand. It's not like someone's coming to play the ping pong table from another site. We looked at specifically the uses that were prescribed in this staff report. So I couldn't be able to speak to additional demand that might be generated from other uses besides office and a coffee shop, specifically because the event center that is on the site, we conditioned that they had to maintain inside anyway, so there was no potential for them to impact additional demand by having outdoor space use.
Okay, and then so I want to make sure I understand the parking study, the comparable properties that were analyzed. It doesn't look like to me that peak demand for parking ever exceeds 62% of available inventory somewhere. So it's what was analyzed is what may be required by code and what is actually absorbed on a day-to-day basis in these other facilities. Nothing ever exceeds capacity. Am I reading that data correctly?
Yes.
Okay. So then so I want to understand that as staff has this laid out in the occupancy in the current property is only 40 some odd %. So we know that all the parking is not being used at this time. But at the point where it could be leased up to a greater percentage, then this parking management plan has been put together and it offers 4 mitigations. In the mitigations, as I read them, I'm a little bit, I want to kind of get some clarity on language. Mitigation 1, the property owner should enter into an off-site parking agreement. Number 2 is the property owner may implement a valet parking operation. And then installation of mechanical parking lifts in a mutually agreed upon property. It doesn't say, it just throws it out there as, that's an idea, but it doesn't say may, should, will, whatever. And the only thing that it says is mitigation number 4 is the property owner shall agree to cooperate in the strategic lease of a vacant space. So that, all those mitigation, the language is a little sloppy to me, and I can't tell which ones, are they all shalls, are they all mays, are they all would? So I would want some clarity on that from the management plan. I have some thoughts on the management plan, but I don't want to get ahead of my skis here because I want the applicant to be able to speak. But those are generally my questions, and you don't have to deal with that now. I just wanted to put that out there. Any other questions for staff and the commission? Okay, I'll open the public hearing and ask the applicant to come forward, please. The applicant here, yes. Yes, sir, good evening.
Good evening. My name's Park Miller. I'm with Lincoln Property Company. We're the property owner. I'd like to say thank you guys. Congratulations for making it here tonight. It's been an eventful night. And thank you to Daniel and Jennifer. You guys have been fantastic. We've been working on this for a long time, back and forth, and it was great to have cooperation and support from your staff. They did an awesome job. So I won't go into too much detail because I know you guys have a binder, full of details, but Lincoln is a 50-plus-year-old commercial development firm located throughout the nation, but we're very city-based. So we have an office in Orange County. Our Orange County portfolio consists of almost 6 million square feet. Mix of office, mix of industrial, mix of retail. We're building a big project out in Tustin right now on the Tustin Legacy base that's about to finish. That's a great example of the type of products that we build, especially the office world. And I think that, going back to when we acquired this property, we just think it has all the potential in the world to be a really dynamic employment center and be a lot different than it is today. I'm sure a lot of you, when you got the agenda report, you probably saw the address and you're like, which building is this? Is it this building? Is it this building? No, because it's just 4 beige buildings that have just been deferred and run down over time, and you get the type of tenancies and the type of companies that are attracted to that. And our goal is to go in, take that same physical real estate, make it cool, invest a bunch of money in it, bring in the art, bring in the design, bring in the new facade, create those amenity spaces so that you can attract the best and highest quality tenants to this project, and to a certain extent we already have. And then I think what came naturally for us in kind of thinking through how we would create a one-of-a-kind environment for our tenants is to think through what those tenants want. And numbers 1 and 2 in no particular order are food and beverage, convenient on-site access to food and beverage. So that's why we proposed the coffee shop. It doesn't function any differently than a deli in an office building that this Costa Mesa has in probably 90% of their buildings. It's convenience and oriented. It's just cool, and it's great coffee. You should try it. And the other piece that's really interesting is as we were working with Jeff Tanner and Fieldwork, who Jeff's here tonight as well, is we came across this concept of the types of tenants and small businesses that our tenant base will consist of, being able to offer this amenity conference and event center where a tenant that has 5 employees can go lease that out for a day during normal office hours when they're on site already and host a team luncheon or a seminar or something. It was just such an incredible value proposition, so we're fortunate to be able to put that together. But the Fieldwork team and us have been lockstep in this, and we're both being thoughtful about how we're creating these provisions and agreeing to conditions and we want to make it work. We don't want there to be any sort of problems or conflicts if we can control it. And so I think what we've put forth is really took a lot of time to get to this point, understandably, but we're really excited about it and totally open to questions or comments or anything you guys need from us on that respect.
Okay. Thank you, sir. Commissioners, any questions for the applicant? Okay. Commissioner Zick.
Well, thank you. Thank you, Mr. Chairman. I didn't want to have him go sit down without at least acknowledging what I think is a really cool-looking project. I'm kind of excited about this. The question I have about this coffee shop, so it's open to the public. And my two questions about that is, are you anticipating any dedicated parking associated with that coffee shop so that somebody from the public that's intending to show up just to do business there would be able to find a parking spot? And the second question is, with that being open to the public, do you anticipate there being advertising, some signage out on the street? How do you envision that functioning?
I think there are no dedicated spaces to the coffee shop. As a part of our responsible parking plan that we've come up with, there are a couple of short-term spaces that are really designed for, Uber and Lyft and ride sharing for employees that are coming to the site. So there are a couple of short-term parking spaces actually right in front of the coffee shop itself. But there's no dedicated, encouragement at this point for someone to come and grab coffee and then go. That's certainly, we want to support the coffee shop and make sure it's successful in a lot of respects, but we also don't want to obviously create, traffic and a bunch of new cars onto the site by doing that. And sorry, what was question two? I lost my train of thought there.
Advertising to the public, would there be signage out on the street?
We encourage a lot of our tenants to have signage because we encourage them to make real estate their brand. So I don't know. I know we have a signage program that will come up, I believe, through you guys at some point potentially. But at this point, we're assuming just generic, coffee and juice signage somewhere on the facade of the building, in addition to the Fieldwork Company logo, and then maybe one other sign on the front of that building per the program.
Okay, and then my only other question has to do with this parking management plan. So as it's written, it obligates you to take care of any problems associated with parking in the future. So we look at the parking analysis and kind of shows that maybe you're a little shy on parking, but maybe we're not too concerned about that because there's a parking management plan that says if there really is a problem, you got to take care of it. Right.
Look, it's not, obviously as a property owner, it's not great for us if we have a parking problem. That's not, especially in a non-retail setting, like this, which is office. People want convenience, and you better believe we're going to be thoughtful about how we're leasing to tenants. And this is not going to be like big mortgage companies that are going to cram a bunch of people into space. It's really going to be entrepreneurial companies that, some of which are already in Costa Mesa, others are going to come to Costa Mesa for this project, I have no doubt.
Yeah, I noticed in your parking plan, you indicated that the leases would contain exhibits and language that basically first come, first serve, you're on your own, kind of a...
Sure, encourage people to ride share and carpool.
All the good stuff,
kind of stuff.
Yeah. Okay, thank you, sir.
Yeah,
Thank
sure.
you.
No problem.
So before we move on, there's a bit of housekeeping that I forgot that I need to ask you. You read the conditions of approval? Yes?
Yes.
And you agree with them?
As far as I know, yeah. Yes.
Would you like to reread them?
Yes.
No,
No,
Okay.
we're good. We're good.
All right. Commissioners, any other questions of the applicant? I have one, but I'll combine it. If the commission added a condition that the implementation of a shared parking agreement and a valet parking plan were required as a condition of approval tonight and not wait until we find out whether or not you're going to have the demand, would you be able to live with that?
Obviously, you're putting me on the spot a little bit, and I'd have to talk to people. But I think the problem with a shared park. So, big picture where we are today. We do office 95% of our portfolio. We know what our parking ratios are. We know what our tenants are going to want. We don't expect even at 100% occupancy that we're going to have a problem. Admittedly, we've got the report where, it is what it is. And so I think to implement a valet program on us and a shared parking agreement, which would be 2 separate monthly expenses, effectively at the end of the day, the people that are paying for that are the tenants, because the tenants pay for the operating expenses for the property, including parking. And so it's kind of creating an expense burden on them that may either break them or hurt them, or it may push them away from this project as opposed to others. And so that's why I think we came up with this kind of thoughtful approach of, all right, it's progress. We're checking at different occupancy levels, at different lease-up levels to really kind of gauge how the parking is. And we've agreed to that. And we've got a lot of properties that are parked at ratios that are lower than this. And so I think we're used to the type of operations that we would expect. And that's why I say that it would be hard for us to agree to valet or even leasing an off-site lot. There's other dynamics with leasing the off-site lot that the other owners would have to deal with, but valet parking would be a really kind of big expense for our tenants when we don't know if it's absolutely necessary.
Okay,
today.
so I understand that. I'm sensitive to that, and the reason I'm asking is staff recommendation or in the conditions of approval limits your events after 6 p.m. unless appropriate permissions of the owner and director of development services are obtained. So I'm only thinking back to previous event places that we've approved. We required a shared parking plan. I'm thinking of the one on Calamus, I think. And so in exchange for that, if you can provide those spaces, I would have far less qualms about allowing day events before 6 p.m. So that's the only reason I'm kind of bringing it up, is I would rather than having you to have to come back here, what can you reasonably do within the parking management plan now that you can kind of dump into your pro forma and see if it works or not, that kind of safeguards you from having to come back, and it may actually give you the ability to do events prior to 6 p.m. and not just after. That's why I asked the question.
I think it's a good point, and we actually left that open specifically to the clause that you mentioned, because if Jeff and the fieldwork team, want to have a big event during the day, then that's something that the city should agree to, but it's also something that we as a property owner should agree to, because we don't want to allow an event to happen that would generate 100 new cars to the site that would then preclude our other office tenants from being able to park on the site. And so that's why we set the agreement up how we did it, so that in those events, and if fieldwork comes to us and says, hey, we have an event, this is the date, and we know we're 60% occupied, then we can say yes as long as the city approves, and we can kind of have that mechanism in place. But we didn't want to do it by default, mainly because of the cost and mainly because this property isn't always going to be conducive to a daytime event, even if fieldwork wants to do it or we want to do it, because there may just not be parking for it.
I understand. Okay, thank you very much.
Sure.
Okay, I will open the matter up for public comment. Anyone wishing to speak on this, please come forward.
So here we go again. Under park, and could you please ask the applicant if he has had an event center in any of his properties before? Because if any of you have ever worked with an event center or even been to the one, what's it called, Fed out there, it is so underparked. Have you been to an event out there? And they have valet parking. And by the way, have you ever been in a coffee shop in Costa Mesa that doesn't have parking problems? And you're saying this one isn't going to? And by the way, I have a Allstate insurance company in that building, and even now I have trouble parking when I go out there in that building. So I don't know why they're saying there's no problem with parking now, because I have had actually parking problems there, both in the late morning and late afternoon. And so also, don't a lot of people work later than 5 o'clock? I mean, I know a lot of people that stay late in their offices. and you're just assuming everybody's going to clear out for an event. I think it's already 61, it's underparked. Can't you do something about this? Thank you.
Thank you. Yes, sir.
You guys may know well enough to say that I don't mince, and I pretty much speak my mind. But when I hear a good idea, Zeke, I try to jump on it. I'm very disappointed in you guys on the last one, and then I'll get to this one. When a property owner is willing to spend his own money on the property and invest in city property, is Public Works going to go out there and fix those sidewalks where those ficus trees are? Because now that becomes our burden as stewardess of Costa Mesa, and now we got to deal with it. So we'll figure out how that one works out. But usually a good idea is a good idea. It meant a lot to them to get the extra parking. And then the next thing we're talking about is another project in Costa Mesa who is underparked by a fifth, 61. City Hall parking lot is underparked. And if I go there to a council meeting on a really busy night when there's a massive agenda, I can't find a parking spot. And I don't do an Uber, and I don't do a Lyft like some other people might do, and I don't drive a Prius. So how does that work for me as a constituent in Costa Mesa? And if I want to go and have a cup of coffee, for example, at Starbucks on the corner of Fair and Newport Boulevard and Fair Drive, try to get a parking spot in the morning. You can't. It's a coffee shop. And if people are going to come out and it's going to be as successful as the property owner's suggestion, which I hope it is, then people are going to come in and park their butts and get on the computer and do their thing and hang out. It's got open space. Where's the tenants going to park? Not a good idea. So if we're going to say shall, will, maybe in the wording of the conditions, no, mandate it. And if it costs more money, it's his money, not our money. Hate to say it, I hate when City Hall comes in and tells me what to do on my properties, but if you're going to not give somebody that's willing, then why are you giving it to somebody that's not willing to commit to a contract with the city? It's a question. It's something that should be addressed prior to an approval. The other guy was willing to negotiate with his tenants. Not his tenants, his neighbors. He was willing to put bigger trees. He was willing to give you a bigger easement and buffer. I didn't hear it from this guy. I don't know either one of them. I have no vested interest in either one of them. But a good idea is a good idea. And when you guys are the stewards of Costa Mesa, when you hear a good idea, you should take it.
Thank you, sir. Any other comments on this item? Okay, I'll ask the applicant to come back up if he wants to rebut or provide any closing remarks or subject himself to further questions from the commission.
Thank you. I have no other comments.
Okay, thank you very much. I will close the public hearing and bring the matter back to the dais for commission discussion and or a motion. Not all at once now. A lot of page flipping, but no motions or comments. So,
I'll comment. I don't have a motion yet, though.
Okay, Commissioner Woods, please.
I agree. I'm uncomfortable. I like this idea. I really do. I like the outdoor space. I can't tell you how many office parks I'd sat at where the only people enjoying that little patch of grass in between were my kids. And I think, why aren't they doing something more viable with this space? But I share the concerns about parking. It's a really tough space. There's Pullman is a really fast street. I know I speed down it all the time to go to some other businesses along McCormick. And thinking about shared parking agreements, I can't think of another space that you could share with where you would be able to transport pedestrians safely across Pullman. I mean, maybe across Paularino. But I'm still really uncomfortable with the deficiency, despite the, how great the design is, how creative the use of that outdoor space. I think there isn't a coffee shop in that area, and I guarantee everyone is going to flock to it, and they're going to stay for a while. I think the coffee shop is gonna tip your parking balance a little more than the office spaces were. You've mentioned that that your average residency or average occupancy was between, I think, 81 and 90% was listed in your letter, and even that I don't think the parking so much is going to come from the office spaces so much, but really the coffee shop. I think that's going to be a real attractant in the area. I concur with Commissioner DiEricol that rather than wait and institute this parking management plan with sort of unclear language for each mitigation measure, we should just tie it into the CUP. We should attack it right now. I don't feel comfortable having such a high deficiency. It's not like 10 spaces. It's not, we're not creating 16 extra spaces. We're deficient by a whole lot more than that. So I'm open to any other suggestions, any other solutions. I think the most viable one that I've heard so far is to integrate some of those mitigation measures directly into the CUP right now. I would entertain a continuance if we need to, but it seems like you've been working with planning staff for such a long time.
Okay, Commissioner Zick.
Thank you, Mr. Chairman. I heard the number of 61 as being characterizing the parking shortage, but that's not the case. Not according to the analysis. Staff report page 7 identifies that deficiency as 35, and that's associated with scenario B, which is what has been recommended for approval. Scenario B, meaning that the event center can only be used off hours. The condition of approval, number 11, states that that there must be a parking management plan, and of course we see what that is in concept here. We had an applicant here earlier tonight that 6 years ago got his plan approved and said, don't worry about the parking, I'll do whatever it takes. If we ever have a problem, I'll do whatever it takes. That was a condition of approval. He said, I'll do whatever it takes. And it didn't include, I'm going to come take city land and have some good ideas. No, he said, I'm going to do whatever it takes. Now you have a management plan here also that kind of says the same thing. You'll do whatever it takes. And I think the linkage between that spirit and what the management plan actually says is a little bit weak, and I agree with Chairman DiEricol that the idea of may and shall and the way that language is a little bit loose. I'm very supportive of this plan, but I feel that's just a little bit weak, and I'd have a hard time approving this today with that weak language, and I'm wondering if you had more time to work with the city to tighten that up, if that's something you think you could do.
Okay.
Thank you, Mr.
Chairman.
Chairman.
The extent of your comments? Okay. Any other commissioners wish to comment? Vice Chair Harlan, Commissioner Colbert. Mr. Vice Chairman.
I don't know where to start on this one. I very much like the idea of the project, and I think that many people don't get terribly excited about reuse of office or even light industrial space, but I think this is a particularly well-designed project, and I think it's just the kind of development we're looking for in Costa Mesa, particularly this area of Costa Mesa. I'm less concerned about the parking issue than some of my colleagues here, partly because the mandated language is in condition of approval 11. It says, if city staff finds that there is a documented parking issue on site, applicant shall institute a parking management solution. And while that might not give everybody the kind of assurance that they want, I think the traffic parking management plan was intended to provide options to solve it. And we may not know exactly what those options are, or what are the best ones, or the most cost-effective ones, or the ones that actually make sense to the property owner. So I'm willing to go down this road, provided that we do have that mandated language, and clearly this gives the city a hook if in fact there is a problem. I mean, that's basically why we have conditions of approval. I don't think I need to say too much more on this, other than I still find the parking issue to be in many cases overblown. I mean, I think the last public hearing is an example of that, where we hear repeatedly we need parking, and when we get parking, we have a decision against it. And here we have a seemingly a deficiency that we're not necessarily sure exists at this point. So I'm willing to give the applicant some leeway in trying to figure that out, because I think on balance this is a really good project.
Okay, thank you. My comments, staff says in the report that for this particular use, this event center type use, that the code's silent on a standard for this, and it's new. So this is why we go and we measure other projects to kind of see what parking demand is. And so you get this number that is on Mars, and we have our own parking standards, which were written years ago, that are on Pluto. And so this project just shows me, again, how obsolete and out of date our parking standards are across a whole host of uses. And so I agree with Vice Chair Harlan that the conditions of approval provide us the hook and the authority to mandate a parking solution if it appears, or if evidence shows, that the project is indeed underparked. And so I'm comfortable with that. I don't, to just look at the 60 some odd spaces and say it's underparked, that's by code, and it's for a code that never envisioned this use when it was written. And it's clear to me that the uses in other areas that were studied indicate that our code is out of date. And so apart from that, I think the design of the project is spectacular. I think, as Vice Chair Harlan said, the reuse of these kind of office uses and light industrial uses, and to create creative spaces, to create kind of hives of innovation where people can kind of come and go and have a spot for a while and then move on. I think generally that's where our whole economy and workforce is going. It's telecommuting, it's working from home, I think this kind of project sets up really well for that. I think it creates a lot of synergy among the people who will be there. And I think it's one more indication of how Costa Mesa is kind of pushing the envelope and leading the edge on innovation in land use, particularly land uses, repurposing land uses that are old and quickly becoming obsolete, which is why I really like this project. So I'm comfortable with it as it's proposed. I do want the parking management plan really buttoned up in terms of when you hit that threshold, and the Development Services Director said you've hit that threshold, it won't be a may or a would, it's a shall. And the only thing I don't like in the parking management plan that I would not want staff to entertain at all is the installation of mechanical parking lifts. I hate those things. So I don't even want that to be a potential solution. So I'm going to go ahead and make a motion, I think, to approve planning application 18-29 and ZA 18-41, subject to the conditions of approval and the findings, and find that the project is categorically exempt from the provisions of California Environmental Quality Act pursuant to CEQA Guidelines Section 15301, Class 1 existing facilities.
Second.
Okay, there's a motion by the chair and seconded by Commissioner Zick. Are there any comments on the motion? Commissioner Woods.
I just have one quick comment. You know, at the last council meeting, there was a lot of talk about outdated parking. Now we're again talking about outdated parking. I mean, if we're going to continue evaluating these applications, then maybe we should have a serious pause and update our parking standards, because this puts me on the spot, it puts my fellow commissioners on the spot, and we're trying to just kind of piece it together with the information that's before us inside of this binder. And I personally don't feel like I'm being put in a fair position. I stand by my decision, I stand by the last one. But again, I mean, I think that if we're gonna, if I'm gonna spend my next 2 years, going around in circles with this parking thing, I quit right now. Let's just put our heads together. I know that Mayor Foley directed Councilmember Marr to head a parking committee. There was some discussion about that too, but hopefully if she does, I fully expect the Planning Commission to be part of that, so that we can come to some sort of consensus in updating what our parking requirements are. Otherwise, we're just going to be, we're going to have this conversation over and over and over again. And I personally don't want to keep having this conversation for the next 2 years. I can see that it's inefficient, and we need to do something about it ASAP. So I will be supporting the motion. That's just a side tangent. But again, I think that we should all be part of the conversation.
Thank you for your comments, Commissioner Woods. Commissioner Colbert.
I'd just like to quickly state I support this motion. I believe that this is an amazing design and incredible reuse of the property. I also would like to state that I work within the Met, which is a similar use, and as a millennial and someone who does telecommute or work off-site at times, when I do come, sometimes I don't work in my office and I want to go to a coffee shop or some other alternative use or outdoors, and I think this type of outdoor space is incredible, and I don't foresee a lot of people utilizing a coffee shop outside of those who may work in the space. However, I do think it's a great asset to the entire property, and I do have concerns, obviously, with the parking management plan language, but I believe that can be mitigated later. We have a commission to exercise discretion when we have conflicts like this, and we know that there are concerns with an antiquated parking plan or parking requirements, but, so here we are as commissioners to do our jobs.
Thank you, Commissioner Colbert. Before I call for the question, I want to just express my complete appreciation, Commissioner Woods, for your comments. I think they're valid. I think that if there had not been a parking management plan in the conditions of approval for this project, I wouldn't have supported it. But we have an out or a coverage to kind of say, okay, if you overshoot, you have to do these things to kind of make it up. So I completely understand your position. I know for a fact that the City Council is deeply interested in looking at our parking standards and bringing them into the 21st century. So, in fact, I mentioned to Mr. Setharaman that I wanted the Planning Commission represented on that committee. So if you're willing to participate in that, I would certainly encourage you to do so, because I think your perspective would be important, and anybody else's who would want to. So with that, I will call for the question on the motion.
That motion carries 5-0.
Okay, and that decision is final in 7 days unless appealed to the City Council. And that takes care of our public hearing items tonight. And I believe we've done our resolutions. Mr. Mejia, you have a public services report at the next meeting?
At the next meeting, correct.
Okay, development services report.
Nothing this evening.
Okay, city attorney.
Nothing to report, Chair.
Okay, thank you, sir. So we will stand adjourned until our regularly scheduled Planning Commission meeting of February 25th. Good night, everybody.